Hearing.
Yes.
This week at least we will not take up any hearing. Let us get accustomed to the jurisdiction. Applications handover. Please, applications, all the applications handover. Order 41 matters handover. If it's FMET order 41, wait for some time. We don't know whether we have determination or just chain has determination.
Application land, madam. Application.
Yes, applications, other applications,
in connection with
all applications, please hand over.
Group 1.
No, if it's not application, let the applications come, then they will hear it. Release, yes, those matters to be mentioned, release, correction, please.
Hello, ready for hearing my requesting the list. Order for
Hearing, wait for some time. Yes, please. It's in front of our council.
Mention this matter today so that the can appears along with the main appeal tomorrow. But
Cannot honor those directions.
I have that order.
The application you are mentioning, so that it appears along with the. Very well, please hand over this.
The appeal only with one prayer, let it appear on 12th, my lord, not tomorrow.
If there is a direction, let it appear tomorrow. Ask somebody to be present. We'll pass.
Settle the matter.
Great. Just ask somebody to mention. We'll adjourn it. Since there's a previous direction, let it appear as per page.
Madam, may I be permitted to mention, my lord, group 1 appeal, my lord?
Please, before let us.
Inclusive in the list for hearing, my lord, as per lordship order.
Hearing, please wait for some time because we let us get accustomed to the determination.
But group 1 appeal, my lord, there is a direction, my lord, the matter to appear today. Matter is not listed, my lord. Kindly see the order.
Since there's a change of determination, we'll have our own take on the matter.
Is that, my lord, the respondent, my lord, admitted, my lord, they are processing with the encroacher.
We are not
encroachers,
adding new hearing matters immediately. Sorry.
But not the hearing, my lord. They are trying, but now
You are not mentioning it for hearing of the appeal.
No. What has happened, my lord? They are.
Whatever has happened, what are you mentioning it for?
But
Is it for hearing of the appeal?
Hearing, but my lord.
No. Yes.
For the Mr. Masud Karim, today item number 26 and 27 not today because
No, when the matter is called on, our standard rule is when the matter is called on, keep somebody, he will ask for time, we will consider. Inform the other side.
Yes, ma'am.
41, FMAT,
FMAT, Mr. Shen, you can add it in the list, but we don't know whether we have determination.
My lord has only got the order 41 determination. My lord, order 41 rule 11.
Order 41 rule 11 is regarding the stage of the appeal. But the subject determination is with Justice Shen entirely. The same problem which we faced during Justice Tandon's. You can remember that. Let it appear very well. Let it appear in the list. When we release, we'll release lock stock. Not to today, we will not be releasing. We'll seek a clarification. Yes.
My lord, order 41, my lord.
Mention for the time.
My lord, a section 5 application along with an appeal. My lord, the urgency is the matter.
Application we can add, Mr.
Yes,
Ghosh.
application.
Application definitely.
Because my lord,
without mentioning
only thing it has to be, my lord, if I can only, my lord, beseech your lordship for tomorrow. The executing court has fixed it for tomorrow and possession will be
Does it
handed
require
over.
admission, that appeal?
Yes. My lord, can section 5 and admission.
Well, let it appear under the order 41 rule 11.
My lord, I'll take my chances. In the meantime, if the clarification
Yes.
comes.
Or just write there, ask your learned junior to write order 41.
Order 41.
Order they likhte dein.
Lordship, one mentioning is there for inclusion, Lordship.
What matter? Hearing?
Yes.
Hearing not right now. Call on the list. We have passed a similar judgment as the previous matters, but we are just reading it out formally. Thus, we rely on our judgment dated June 19, 2025, and we have given 1 or 2 lines. Passed in earlier appeals. Accordingly, FAT 159 of 2015 is allowed, thereby setting aside the order judgment impugned therein. Similarly, FAT 160 is also allowed, thereby setting aside. Both matters are remanded to the referral court for the purpose of rehearing of the respective references under Section 18 of the Land Acquisition Act in the light of the above observations. Similar directions as the previous matters, marking those documents and exhibit exactly similar as the previous one. দীপঙ্কর আজকে আসেনি অসুস্থ
Sleep this bunch of matters
yes
has come up in Lojima.
why Lozima
I do not know. This should be actually
We just
FMAT RB award because
just check
it
up
is from
the-
a section 30.
check up the report of the let us check up the report first
What am I doing?
3 থেকে 8
This is section 37.
Yes, yes, yes.
Uh, uh, 2 or 3 defects we are just telling you. You
Hmm.
just go through the report also and rectify. One is that the appeal is classified wrongly because it's a section 37 has to be as
FMAT ARB award.
FMAT. So that renumbering, unless that renumbering is there, whatever order you pass, that will not be tagged with the main file, and this will be shown as pending.
Yeah.
So you have to do that first before. And this caption memorandum of appeal from original order has to be. Not you have stated decree.
Okay.
And the details of the they have stated trial court. Yes, it's trial court because you have stated no, the trial court you have stated the details, the section 34 code. But affirming or whatever, you have to just mention that in the preamble of the memo, Mr. Lahiri.
Right.
Affirming or reversing whatever the award of such and such,
Right.
something has to be given there. So that is another thing. And another important aspect is 393 days delay, they say.
Relay will file. Will
File
Well-
that will give you liberty to rectify all the defects.
Hmm.
Will give you a fortnight's time. The other corrections you can do it right now. We'll give you 1 week's time to. By today you can rectify the memorandum,
Hmm.
the other corrections.
my junior will rectify.
We'll give you till tomorrow because it's logima. Otherwise it comes as final orders.
Hmm.
So we'll give you that liberty to do it by tomorrow. Do
Hmm.
it today. And section 5 also will give you 1 week's time. After 1 week, this will appear under the same heading. If you find that the section 5,
No, unless it is made into FMAT ARB award,
oh,
I
you cannot file that.
file my section 5. Everything is
Very well. We'll give pass the necessary directions. We'll give you liberty to mention as and when the section 5 is
No,
filed.
because most probably my lord doesn't have jurisdiction.
Oh yes,
Determination is before court 37.
right. Before the appropriate bench.
Yes.
You're right. From the office report dated, from the report of the stamp reporter dated July 17, 2025, we find that several defects have been flagged in the appeal. First up, the learned advocate on record appearing for the appellant is granted, is directed, we shall make it direction because otherwise,
Hmm.
logima, is directed to carry out the necessary corrections to the memorandum of appeal as pointed out by the stamp reporter to
Mhm.
rectify the defects concerned by tomorrow, that is August 5, 2025. First of next para, on the prayer of learned counsel appearing for the appellant, leave is granted to the appellant to file an application for condonation of delay in filing the appeal within a week from date. First of next para, upon reclassification, upon recategorization of the appeal in the memorandum, the office shall reclassify the appeal and allot a new FMAT number thereto. Full stop.
FMAT ARB award.
FMAT, ARB,
Bracket ARB
FMAT
award.
within bracket ARB,
Award.
ARB award, very well.
That is the
FMAT within bracket ARB award, bracket closed, to the appeal, full stop. Such classification shall be carried out within a week from the rectification of the memorandum. Full stop. Next para, liberty is granted to the appellant to mention for enlistment the application for condonation of delay as and when the same is filed, before the appropriate bench having determination.
But two corrections I will make immediately. One is appeal from order and affirming
The name of the arbitrator and all you can get from the award also.
from the award.
That
The
also you can
judgment is there.
Your part of this, apart from section 5, you can do right now.
But my advocate record will do.
Yes,
Uh,
he
There are
knows how to.
6 appeals.
Acha, same order.
LA, this is an LA arbitration.
ডিকটেশনটা কে নিল? তুমি নিচ্ছ? আলাদা আলাদা করে সেম অর্ডার কপি পেস্ট হবে 6টা ম্যাটার, এক্স্যাক্টলি সেম অর্ডার।
But she's doing it.
Yes, in all the memo
3 to 8.
3 to 8 same
Or
order.
she will come back at 1:15 and do it. I think that is the better.
Whenever they have some respite and you have some respite.
Yeah.
ফাঁকা পেলেও রিসিভ
একটা
করে
15 Apply. নামটা দিয়ে দিয়েছিস?
এটা ডিটারমিনেশন আছে আমাদের এটা কিসে ঠিক ল্যান্ড রেভিনিউ আচ্ছা ল্যান্ড রেভিনিউ ম্যাটার
No, yes, land revenue.
No, land reform.
Land reform.
It is
Revenue-
still wrong-
determination
wrongly typed.
that is the only question that
Yes,
we
yes.
have
well,
what is the matter Yes, Mr. Ryan, Mr. Galip, teach us what is the law on this.
Expeditious hearing,
Oh,
not standing in the way.
So for the expedition, apart from that, my lord,
The appeal.
no,
Appeal from lordship, this,
append my lord in this matter, my lord, if your lordship only. Initially, the record of rights stands in the name of the vendor. There is no recording in Nestor and Borgadar. I purchased, my vendor converted the land into from Shali to Bastu,
And then sold.
then sold. So I have been sold a Bastu land. I have made construction and I have also recorded my name in the record of rights. Consequently, the private respondent herein filed an application stating that he is the Borgadar and his name was not featuring in the record of rights. Considering the same, my lord, they filed an application for recording his correction of name. On the basis of which the BLR concerned, or the Bhagchas officer, my lord, because it is under the Bhagchas proceedings, Bhagchas officer held that yes, you are not entitled to get any because you are not a Borgadar. Challenging that, an appeal has been preferred. Now, my lord, only one thing I draw your attention about the appellate court's order, which is subject matter of appeal before the tribunal. Once, my lord, if your lordship can turn to
176,
176,
impugned in the way.
which is impugned in the way. Relevant portion is, my lord, (178). It starts from 174, relevant portion 178.
Yes.
Issue number 1, my lord, got it? Issue number 1.
Mhm.
It is established no proceedings was initiated of Borgadar and no logical thought has been used out for the proceedings. So
His
there is
English is probably like Mr. Galip.
a high class one.
Proud, very proud. So strong reason to infer.
It is established principle of law that any suit obtained by playing fraud is a nullity or nonsense in the eye of law and does not become a binding precedent of collateral bindings or cannot get advantage in connected proceedings. My lord, I could not understand what is the ultimate decision made. Next, at the time the Borga was not removed in accordance with the legal procedure.
You cannot decide the appeal now.
No, what happened?
They
My lord,
decide the main challenge.
yes, the Honorable can consider this order is impugned before the tribunal. Tribunal initially passed an order of stay. After passing the order of stay by landed friends, client,
You are for the private respondent.
Yes,
yes,
You are the Borgada.
Yes, ma'am.
yes, Borgada.
Since 1965,
No, we are not going to the merits.
and
Now-
this is pending before the tribunal.
Are these reasons?
14th May is the date, kindly prepone.
14 May 2020. What, my lord, only one thing.
We'll direct the hearing.
My stay application.
They are
We'll direct the main matter, challenge before the tribunal to be decided along with the stay to be heard out finally on the next date.
Next date is after 1 year. That is why, my lord. 14th of May 2026.
14th May
14 May 2026.
My lord, why, my lord, the initial interim order was granted?
Tribunal may be hard pressed, probably that's why. Because you're enjoying an interim order.
Or interim was granted.
We'll direct that to be done within a reasonable period within
because unless until because already there is
the
a
hearing is required.
they are
order has been recalled. Balarkali conversion, my building is there. Order has been recalled. Balarkali consider this effect. I've constructed the building on the basis of the conversion certificate. I've constructed a building.
No, that order has been stayed.
No, that order has been recalled by the appellate authority, which is subsequently imputed before the tribunal. Tribunal initially granted an order of stay, but it subsequently appears that before passing the order, one of the person died. We filed an application because order cannot be passed against a dead person.
So therefore that has been allowed. We'll direct all
It's
the
been allowed, but the order of granting stay that has been kept for hearing on.
So we'll direct the stay application to be taken up and decided on the next day and decided within a week from
My
that.
We
Only that
My lord.
at this.
only by injunction that application was not 14th May 2026.
No. Oh, not then within a limit, say 3 weeks from the date of communication, we'll direct.
Can
it
get
to
full.
the
That is only
interlocutory application.
only that.
Only interlocutor.
We'll do that.
Yes.
Let it be done.
The present challenge is confined to the delay in adjudication of the
Application of
challenge preferred
Application.
before the tribunal
Amy.
by way of miscellaneous case number 26
No,
of
1495.
No, what is the main number?
1495.
OA number
1495.
Way number you have only.
It's-
Acha, very well.
there
You
are
have stated only miscellaneous, not in connection with what?
Way
Prayer
number is
portion.
2
In the prayer portion, have you stated
Okay.
arising out of way number?
Yes, my lord. Way number 286, page 183, my
Oh,
lord.
right. কোনখানটা ছাড়লাম গো শঙ্খ? না, miscellaneous কেটে দাও. By way of way number 2865 of 2024, as well as the connected stay application bearing miscellaneous case number 1495 of 2024. Full stop, next para. Learned counsel appearing for the petitioner argues that although the stay application was initially taken up, due to the demise of one of the parties, a substitution application had to be taken out. Full stop, even after the same was allowed, the application, the miscellaneous application for stay was postponed for hearing along with the main OA, and the next date has been fixed on May, which date?
14th May 2026.
May 14, 2026, which is about 1 year hereafter. Full of it is contended that the valuable rights of the petitioner will be affected due to the inordinate delay in postponement of the stay application. Full stop, next para. Heard learned counsel for the petitioner, the state as well as the private respondent. Full stop. At this stage, there is no scope of entering into the merits of the respective contentions of the parties. Full stop. However, it is apparent from the nature of the matter that there is urgency involved, at least with regard to the stay application pending before the tribunal. Full stop. Accordingly, WP LRT 112 of 2025 is disposed of by directing the West Bengal Land Reforms and Tenancy Tribunal to dispose of miscellaneous case number 1495 of 2024, pending in connection with OA number 2865 of 2024, as expeditiously as possible, positively within 3 weeks from the date of communication of this order to the said tribunal, upon giving opportunity of hearing to all parties. Full stop, next para. Upon disposal of the same, the tribunal shall endeavor to hear out and dispose of OA number 2865 of 2024, as expeditiously as possible, by preponing the dates and preferably within December 31, 2025. Full stop. No address to cost. No address to cost.
Grateful to your lordship.
Yes. No matter.
Your lordship, I'm praying for next Monday. Lordship, I'm praying for next Monday.
Registration application. Can is pending since 2020. Why didn't you mention it? You are for the opposite party or the
I'm
petitioner?
for the petitioner.
Why didn't you mention it so long?
Lordship, I'm praying for another thing also. There is another analogous matter, that is Kirodroy.
No, did you file this application within time? Yes, within time. Let us allow this application, whatever is analogous.
Analogous matter. So I have served a notice upon the Advocate General. Kindly.
You want that to appear along with this?
Yes, Lordship.
You don't want us to allow this now?
I also want this, but I want that let it be
Very well.
together.
What is, this is that CAN number, the other one?
Another one is this one.
What is the CAN number? বুঝতে পারছি না এটা থেকে। CAN 1315 renumber হয়ে কি হয়েছে? CAN 3. No, this is the present appeal, second appeal.
Yes, Lordship. And
But
Kirodroy
now,
is the
sorry,
analogous
1 minute. We don't have determination now to hear this matter. Because this recall application was passed by a bench which was taking up an order 41 Rule 11 at that stage.
Yes.
We don't have the determination. Order 41 Rule 11, yes, we have. Right.
Okay.
This, whatever you have handed up is regarding this appeal itself.
Yes, yes.
So you are
but
saying an analogous matter means what analogous
that
matter?
that Khirodroy matter is the same matter. So it was in the same condition and the status is showing the same.
Why didn't you mention it in the morning? Mention it separately tomorrow. We'll add it in the list. We are allowing this application for the time being.
Okay. Thank you, Dr.
The present application for restoration has been filed for recall of an order dated January 17, 2020, passed by a coordinate bench, comma, dismissing for default the second appeal. Full stop, next para. From the said order, comma, we find that none were present for either of the parties. Full stop. As such, comma, prior service of notice is deemed unnecessary on the respondents. Full stop. Moreover, comma, since the application is otherwise in time, comma, and sufficient explanation has been given for the absence of the appellant on the relevant date, can 3 of 2020 within bracket old number can 13/15 of 2020 is allowed, thereby recalling the order dated January 17, 2020, passed in SAT 264 of 2018 and restoring the said appeal to its original file and number. First up, let the appeal be listed for hearing on August 6, 2025 under Order 41 Rule 11 of the Code of Civil Procedure. This will appear for Order 41 hearing on day after tomorrow. And you mention the other matter tomorrow morning, we'll take that in the list also. Or you can hand over slip right now regarding the other matter. Hey, Anandita, উনি যদি স্লিপটা দেন না অন্য ম্যাটারটা একটা স্লিপ করে দেন number right now. Yes.
My lord, I am for the respondent opposite party in this matter. My lord, may I be permitted to file the opposition? My lord, with the leave of the court, may I file it?
There was a direction previously.
No, only restoration application, there was a direction to serve only.
Very well, if they want, will permit them file a reply by 3 days.
Yes.
Not 3 days, my lord, week.
1 week.
1 week.
Very well. On the prayer of learned counsel for the
A copy is given.
respondent, comma, an affidavit in opposition is filed in connection with Can 2 of 2024, full stop. Affidavit of service is filed by learned counsel for the appellants, which is also kept on record. Full stop. You have already got a copy of the opposition?
Yes. That's
Achha. A copy of the affidavit in opposition is handed over here and now to the learned advocate for the appellants. Full stop. The appellants shall file their affidavit in reply, comma, if any, to the opposition within a week from date. Full stop. Let the matter be listed under the heading application on August 11, 2025.
Only one thing, my lord, the opposition which my learned senior friend is, my lord, filing today, my lord, this is to a restoration application. It was, my lord, dismissed at a point of time before admission where Order 9 Rule 4 principles will apply, whether they may be at all permitted to oppose. They did not appear.
Yes.
Arekta line
My
as
lord,
per-
your lordship has given.
Another line as per the
direction.
learned counsel for the appellants, comma, at this juncture, comma, raises a question as to whether an affidavit in opposition can at all be filed by the respondents and or whether the respondents can oppose such an application, comma, since the appeal was dismissed for default at the stage of hearing under Order 41 Rule 11 of the Code of Civil Procedure, comma, at which stage the respondents do not have a right of hearing. Full stop. Learned counsel for the respondent opposes such contention. Full stop. It is made clear that the question of maintainability of the contest by the respondent to such an application is kept open for being decided at the time of final disposal of the application.
As per your lordship direction, I am appearing, my lord. I am not automatically, I am appearing.
We'll consider that. There was a direction on.
Yes,
for-
sir.
Restoration.
Therefore, I am appearing.
No, he's not blaming you. I mean, whether you have a right in law,
Yes.
we'll
I am
consider it.
right. Application is there, my lord. I have every right to give opposition.
Yes, next.
Well, my lord, I am for the petitioner appellate. No, this is my lord, application for restoration, my lord, the
Application for?
restoration, my lord.
Was it filed within time?
So, my lord, this is for default for non-appearing, my lord, the When the, my lord, the order 41 is called for my lord admission.
No, the question is when you filed the application. 16th of August. So 30 days was the limitation. You had to file it by, say, about 15th or 15th of September. You filed it. There's a 1 month delay. You have to file a stay section
Lord, I
5.
have filed the stay application also, my lord. This is
No, section 5 application. This is delayed. The application is delayed. File a section 5.
delayed. October, August.
And you have not explained the delay in this application.
Well, this application was filed in the month of October, just after the passing of the
30 days is the limitation for restoration application.
restoration application. Within 16 days, it was filed.
Before
Within 16 days, it was
16 days.
filed. Order was passed on the 16th August 2023, and this application was filed probably on the 11th of October 2023.
According to you, that is within 30 days.
No, sorry,
16th of August to 10th of October.
after 30. Sorry.
You are worse in mathematics than
Sorry,
me.
sorry. Well, of course, well, I am weak in mathematics. That is why, well, I have not taken science, well, in.
No, you have provided a competition to me. I had that position of honor that mathematics I am very weak in calculations at least.
Simple calculation, well, this is a calculation made by.
No, we are
maybe, well, made by
probably
the
better in
student
greater
of the
things.
class 1, 2, 3.
We are probably better in greater things, greater calculations. Maybe let us have that. Anyway, we find prima facie, ex facie that the application is barred by limitation. Full stop. On the prayer of learned counsel for the appellant, comma, liberty is granted to the appellant to file an application for condonation of delay in filing Can 2 of 2023. Full stop. Next para. Let the matter be posted in the list under the same heading on August 18, 2025. Full stop. The leave is the learned advocate for the appellant is granted leave to mention for inclusion in the list and tagging along with this application the proposed application under section 5 of the Limitation Act, comma, as and when filed.
Kindly make it over 25 times.
20
15 minutes, I will be out of station.
Acha, August 25th. August 25th. Acha, the appellant shall serve copies of both the applications in advance on the respondent. This was filed at no.
At the stage of the
Soft copy to diyo na. Soft copy to. 25th August next returnable. Thank you.
Good.
Whenever you file the section 5, please mention it. We'll include. Yes.
Can 1 is an application, my lord, for restoration. Can 2 is an application for condonation of delay. My lord, copy দিয়েছে?
What is the meaning of this formal order of dismissal?
My lord, the learned Lojima bench, my lord, Lojima court, the registrar Lojima has drawn up a formal order of restoration. My lord, the honorable division bench directed that if deficit court fees is not paid within such a time,
By default.
automatically.
No. It was at the final Lojima final order stage.
So, my lord, those are not followed nowadays after my lord and
The first stage of Lojima.
After superannuation of Justice Mukherjee, my lord, those are, my lord, completely are not followed.
Not followed. So this was the first.
Kindly takes up, my lord, page 8.
Of which application?
Can 1. This was the first reporting, 27th April 2023. Then, my lord, I was given a chance, page 9, 17th May 2023, peremptorily. Then, my lord, formal order on 22nd
So
June.
you never deposited that?
Never deposited.
Could not deposit because it stood.
Yes. Now,
How soon can you deposit that? If you
Lord,
we have not heard you as we'll hear it.
by
Please.
Thursday. By Thursday.
By Thursday, you have to be ready with that. And what is the amount? 112.
112.
Deposit from your own
Yes.
pocket today.
And
Oh,
my lord,
Thursday. 112 rupees.
my lord, Can 2 is, my lord, section 5 application.
What is the delay?
677 days, my lord. My lord, I have given the, my lord, scan reports and medical reports, my lord. He could not.
Same advocate on record still there or you have changed?
No, Milord, not different. Earlier, Mr. Shamol was there, Milord. Now, Milord, Gaurav Ghosh, Milord. Earlier, Mr. Shamol was there, Milord.
No blame has been cast as such. That the erstwhile advocate said that he had missed the list on the day, and once you miss the list, then we know what happens. So yes, why shouldn't we allow it?
My lord, only I'm saying, my lord, all the medical document are after dismissal of the order of the honorable.
I'm sorry, please repeat once.
After, all medical document is after dismissal of the honorable court's order, my lord.
No, that is for the delay.
Yes, yes.
That is for the delay.
Yes, yes. We could
No,
not
that,
keep
regarding the absence on the date, page
I
paragraph
have
9.
nothing to say, my lord. I
Paragraph
leave it
9
to your
of
lordship, my
Can.
lord. I leave it to your lordship.
Can 1 of 2025 is an application for condonation of delay in preferring Can 2 of 2025, comma, the latter being an application for restoration of the appeal. Full stop, next para. We take up the averments made in both the applications, comma, since those are interconnected insofar as the explanation for the delay and the absence of the appellant on the relevant date are concerned. Full stop, next para. The case sought to be made out in the applications by the appellant is that the appellant was unaware of the dismissal of the automatic dismissal of the appeal due to non-deposit of meager amount of court fee of rupees 112. Full stop, next para. Learned counsel for the appellant submits that the petition appellant, comma, immediately after coming to know of the same, contacted his erstwhile learned advocate, and now who gave out that the matter was missed in the list on the relevant date, and as such, comma, the dismissal was not detected, comma, only before much subsequently, comma, information was sought to be taken at the behest of the appellant. Full stop, next para. Heard learned counsel for the parties, full stop, next para. It appears that sufficient reason for the delay has been made out in the applications, comma, inasmuch as the appellant was indisposed medically for a considerable period of time after the dismissal of the appeal for default, and is of advanced age of 75 years. Full stop, next para. That apart, comma, we find it entirely plausible that the erstwhile learned advocate for the appellant had missed the matter on the list, comma, which ensued in detecting the order of this court much later. Full stop, next para. A third issue which has cropped up is whether the coordinate bench of this court, comma, at the first stage when the matter was to appear under lozima for orders, comma, could have passed an order whereby the appeal would stand automatically dismissed without further reference to the court, comma, without putting up the matter for under the heading lozima for final orders as per the rules and the practice of this court. Full stop. Upon hearing learned counsel for the parties and adverting to the above issues, comma, we are of the considered opinion that the delay in referring the application and the absence of the appellant on the relevant date has to be condoned. Full stop. Accordingly, Can 2 of 2025 is allowed, thereby condoning the delay in Can 1 of 2025. Full stop. Can 1 of 2025 is also allowed, comma, recalling the order dated May 17, 2023, passed in SAT 55 of 2023, comma, thereby restoring the said appeal to its original file and number, subject to the condition that the appellant rectifies the defect pointed out at the relevant juncture, comma, and deposits the deficit court fee of rupees 112 by tomorrow, that is by August 5, 2025, positively. Full stop. Next para. In the event the said deposit is not made, comma, the both the applications shall stand automatically dismissed. We make this order, although we should ideally have posted it again for lodging for final orders, but that stage is over now. because it has been dismissed. Thank you. Subject to the deposit being made, comma, let the appeal be placed under the heading Order 41 Rule 11 on August 18, 2025. What are the applications?
But there are in appeal number 2030, I have filed an application for dismissal of their rejection of their attempt to disclose new documents. That's an application.
The appeal was admitted formally. There is a
The
need for
appeal was, no, my lord, appeal that was not admitted.
there is no
Because, my
section
lord, the
5.
subject, it was subject to maintainability of the appeal. The order was passed by the Honorable Division Bench that it will be heard subject to the maintainability of the appeal. This Division Bench presided over my lord Mr. Justice Tirthankar Ghosh. Well, as of now,
What
my
is the
lord,
date of that order?
date of that order was
The date is 14th October 2024.
14th October 24.
প্রথম দিনের অর্ডারটা কোথায় থাকে?
This is an assigned matter to us.
Yes.
Then, yes.
My lord, there are now
41 Rule 27 applications, Lord, may I file my affidavits in opposition?
But may
You
I
have given
file my-
copies to them.
Yes, yes.
But may I also file my
This is in all the matters.
This is in similar 4127s in
My lord,
the appeals,
since
in
my
all
lord,
three
my lord,
appeals.
the affidavits have been filed, served upon us beyond time. So, my lord, we would seek an extension to file reply.
Mr. Mujumdar, you are appealing for the state. I'm sorry, you are appealing for.
No, my lord, I am appealing for my lord the respondent. State is one of the appellant. In one of the appeals have been preferred by the state.
In item 15, I am the appellant, Your Lordship. 3 applications have been filed by my learned senior friend's client. I am yet to file the opposition to Your Lordship. I seek an extension of it.
Which item?
Your Lordship, item 15.
What is the mat number? Give us.
Mat number 202. I am the appellant, Your Lordship.
2022.
Similar application has been filed by my learned senior friend's client. I am yet to file an opposition to Your Lordship.
To the order 41 Rule 27.
3 applications, order 41 Rule 27, dismissal, and another.
This what we say to that.
My lord, I generally do not oppose. I don't want to oppose. But my lord, when they stay application, we could not file the opposition within time. So, my lord, if they are given an opportunity, let us also file an opposition to the state. It's ready today.
That was
Tomorrow we can file.
Lordship already refused this prayer once.
No, my lord. Then, my lord, I am opposing their prayer for extension.
Your Lordship, do something. I will not stand in the way. Second, Your Lordship, this is my first extension. I am seeking.
But state's appeal, it's not the private party's appeal. State's appeal, my lord, we can file opposition to the
Whose application under order 41 Rule 27 is it? The
my application.
the state's.
No,
your-
my.
In my appeal, his appeal.
Petitioner's application.
Malad, there are 3 appeals. In 3 appeals, we have taken out. Malad, may I just give
You are for whom?
I am for the state. In item number 15, I am the appellant. Your Lordship, there are 3 appeals.
There are 3 appeals. Malad, may I give a lordship the numbers? In MAT 2015 of 2022, that is Regent Vinimai's appeal, correct? Malad, can 2 is for dismissal by the
These arise out of what?
These arise out of
Same
a
judgment.
same judgment.
What? Under which provisions? Under what law?
Read.
Group 9.
Police in action. Arises originally from a police in action order.
Right. But this is an order
Police in action order is.
transferring investigation to CBI.
I'm not one.
There's an interim order till 31st of
Mr.
August.
Mujumdar, we have
Yes.
previously rejected your application, your prayer for extension of time to file opposition on
Right, my lord, you lost.
because ample opportunity was granted.
Yes,
This
yes,
is their
right.
first.
Malad, this state is, Malad, I am not praying for extension or any leave to file opposition with respect to the stay application in MAT 2015 or MAT 2030. Malad, state, so far as the state's matter is concerned, may I be allowed to file an opposition because state is not opposing, Malad, in my prayer.
MAT 2022.
MAT 2022
You want to file an opposition
to the stay.
That was refused previously.
Yes.
Yes.
If you have refused, we cannot recall.
Refused.
Because we had recorded that ample opportunity had already been given to the respondents to file their oppositions.
It was seriously opposed by the private parties.
Maybe, but this is not a retributive
No,
procedure.
no, nothing. In some sense, it is retributive, my lord, but
But I
not,
have,
not between us, not between us.
Not between you at any point of time.
but I have one frame that I am out of time to file that one affidavit.
My lord, everybody is out of time, and when we were out of time, then everybody opposed.
This is a perjury application taken at their behest.
Yes.
One copy is ready. Second copy is
No, whether this is
Second
the first prayer for extension,
first prayer.
first prayer we are allowing.
That's
In
great.
your case, it was probably more than
is ready. The second copy is not ready.
Can two that your lordship will find in the list have been filed by my client, the workers for dismissal of the respective appeals. In
that
respect of
includes
only
the hearing of the appeal itself.
item number 14, only the appellant has filed opposition. In other appeals, your lordship, the appellants have not filed opposition.
So in 2022, you are wanting to file an opposition to
Can 2, 3, 4 filed by Mr. Mujumdar's client.
what is that? Stay.
Your lordship, no. One is order
What about
27 and another is dismissal.
Learned counsel appearing for the state seeks an extension of time to file affidavits in opposition to can numbers 2 and 3.
Lordship, 2 and 3.
To can 2 of 2024 and 3 of and can 3 of 2025 filed in connection with MAT 2022 of 2024. Full stop. Accordingly, such extension is granted for filing opposition to the said application to the state for a period of.
Lordship, would your lordship be pleased to give me 3 weeks?
You have already been granted time. We'll give you a fortnight. For a fortnight from date. Full stop. Next para. A reply, if any, shall be filed within 1 week thereafter.
2 weeks, my lord.
Within a fortnight thereafter. Full stop. Next para. And you are paying for extension
2030. I am the appellant.
2030, which can.
Can 3 of 2024. This perjury application.
And you are appealing for the
I am for the appellant.
learned counsel for the appellant in MAT 2030 of 2024 seeks an extension of time to file affidavit in opposition to can 3 of 2024 filed in connection with the said appeal. Full stop. Such time is also extended for a fortnight from date. Full stop. Replies in if any shall be filed within a week thereafter. Full stop. And Mr. Mujumdar, you wanted to file an opposition too?
Yes. My lord, we will file replies.
Acha. The time for filing the stay you are how shall we refer to you?
My lord,
You are the appellant
refer
in
to us
which
as respondent, but we are the applicants. We are the applicant.
you are the
My lord, we are applicant in can 3 and 4 in MAT 2015 of 2022.
Acha,
We
the
are applicant in can 3 and 4 in MAT 2022 of 2024, and we are also applicant in can 3, 4, 5 in MAT 2030 of 2024.
what is your name? The name of your client?
My lord, this is Agarpada Jut.
Say Agarpada Jut means.
Agarmada Jut.
So can number 2, your lordship, the item number 14 will kindly extend my time to file reply.
What is the mat?
Can number 2 of MAT 2015. 2015 of 2020.
You are for?
I am for the respondent number 8 in that appeal who has filed can 2.
Reply.
Yes,
Time for reply.
correct. Applicants in the cans are allowed to file.
But all the affidavits.
Let all the applicants in the cans be allowed to file their replies. Otherwise, my lord,
And
there will
also
be-
the opposition, my lord, because the affidavits replies,
Consider
right,
the
replies.
application to reply.
Opposition,
Reply.
whatever you have said, only that.
Reply.
Needless to say, comma, all the applicants in the applications in which we have permitted opposition to be filed shall file their replies within a fortnight from date.
Mala, upon receipt of them, the opposition. But in some cases, mala, opposition is yet to be filed. In some cases, opposition is yet to be filed. That is why they sought leave.
234 আমরা AO দিয়ে দিয়েছি।
234 in MAT 2015.
No, we have given a timeline for that opposition. It is made clear that the parties shall exchange their respective oppositions and replies within the time limited for filing the same. So that restricts the time to 2 weeks and what.
Very well.
Filed by our company, there is the issue of dual representation of that appellant. That's been going on in every court. I mean, if Mr. Dasgupta is though he is saying he is appealing for the appellant, my conviction is that I am for the other part who is also.
Whatever you have passed to them, that applies to you.
Filed with a reply.
Your intervention application is still pending.
So can 3 in 2030.
That is the perjury application I have sought not for file an opposition to that.
Kindly allow me to file a reply.
You are the applicant in Can?
Milord, I am not an applicant. Milord, there is a dual representation of Milord ACL, Agarpara Company Limited. Milord, it's going on in everywhere. Milord country.
Appeal is mine.
No.
I don't have the authority. That's my convention. Milord, be that as it may, Milord, allow me to file a reply because I remain uncontroverted.
It's
complicated for
I
us.
am the appellant.
Milord, that has to be, Milord, then done.
Let them file an application.
How can he file reply the application against me?
How do you define you? Because Agarpara company have already permitted.
Every court has defined as Milord dual.
But somebody has to be.
No. Courts have
Somebody has
held
to
that
be.
he has no authority. Courts have held that he has no authority. That is my ground in the appeal. I have annexed to the appeal.
And take it for the Milord Food Court to decide. In 17th November 2020.
We'll also leave it to someone. Name someone who will. Suit court.
The flower is so beautiful. The gardeners want to have.
My agreement was on record.
Before we decide whether you are not a party in the writ court. Oh, acha, party means
Party.
That appeal is mine. He is impersonating. He is an
Well, only one. Well, may I just give you one prayer? Well, subject to your lordship, whatever your lordship may decide. Well, since the state is not opposing my opposition to be filed against their stay, but even if your lordship imposes cost, my lord, we are ready, my lord. If
you
your
have already passed an order.
Pass an order.
How can you recall that? You make your submissions on whatever documents are there.
That he has brought on record by
And
way
you
of the
bring
case.
those documents, should we
That has been
advise you?
brought on record by way of the case.
You will be entitled
Well,
to argue on all the materials
Actually,
which
Mr.
are on
Banerjee is not representing the state. I believe so.
No, that's all right. But
That's-
I can
that's-
understand the strategy.
No, this is caustic versus caustic. We are not interested in this caustic exercises.
Otherwise, I will become Milord uncountable Milord to their.
But it's a question of
How can we direct Agarpara company to file twice?
That the affidavit which is on record by the Milord before the court. It's my affidavit was on record.
But if it is on, if it was on record, then they will be able to proceed from the record. No new, nothing new has to be filed for that purpose.
Can't. They have been representing the company before the writ court also.
He has misrepresented. He has misrepresented me and filed an affidavit.
Well,
That
it
is
is,
the case.
it is,
His director will not file
Stop.
a petition.
it is very clear. It is, তোমায় বলছি এবার। It is made clear that wherever affidavits have been directed to be filed by the Agarpara Company Limited, since there is a dispute as to who are the authorized representatives of the said company, both the rival factions claiming to represent Agarpara Company Limited shall be entitled to file their respective affidavits on behalf of the said company. The above directions of affidavits shall be construed accordingly.
But may I indicate
lordship
one
is
thing?
But
posting
please
this matter-
indicate, we'll take on record. When you take on record, we'll
posting this
note
matter on-
what the rival contentions and who give some indication in your affidavits. I mean, who represented. I mean,
Can it be then, my lord, just
His lordship is also. May I not make one sub? But I am the appellant in this appeal 2030. He is a respondent in that appeal.
Disputing your appeal.
Maybe not, but he is a respondent.
you are a respondent.
He is a
This
respondent in that appeal.
Another appeal.
But in that appeal, he is a
in your individual capacity.
Individual capacity. Responding other appeals. But Milord.
Because naturally, if he is a party respondent, he cannot file this affidavit in reply.
No, then you indicate in your affidavit in opposition to these applications that you may say that you represent the Agarpara company, but you indicate that you are the you indicate in your caption and respondent in such and such, so that we can have a picture.
but your lordship is
You should be unqualified. You are Agarpara.
post this matter after vacation.
After which vacation that we are considering?
At least after Puja.
After Puja
At
vacation.
least after.
No, the Puja vacation definitely, but whether the winter vacation also.
But this is assigned, my lord.
Assigned.
Very well. Then within bracket grudgingly likhe liye. Let all the application be posted for hearing in the list on. Give us a date. We are reopening on November,
Weeks any day, 2 weeks after vacation.
weeks after. So can it be on 11th November?
Yes, your lordship may post the matter, but that is up to you.
Across the board. On November 11, 2025.
Interim order. There's an interim order which expires on 31st of
Interim
August.
orders granted in the granted previously shall stand extended till December 15, 2025 or until further order, whichever is earlier.
Obliged.
my lord, we have put in our affidavits in opposition in MAT 2015 of 2020.
The affidavits in opposition filed today be kept on record.
Yes.
আচ্ছা শুনুন
Can 2, can 3, can 4.
যখন অফ টাইম পাবেন একটু, যেটা খুবই অভাব, যে এই প্রত্যেকটা ম্যাটে আলাদা আলাদা করে প্রত্যেকটা অ্যাপ্লিকেশন আর তার অপোজিশন আর তার রিপ্লাইটা একসঙ্গে সাজিয়ে রাখবেন। হ্যাঁ, মাঝখানে একটা করে সাদা শিট দিয়ে দেবেন, যাতে ডিস্টিংক্ট বা কিছু একটা ট্যাগ দিয়ে দেবেন। কাউকে ওদের করতে পরে যখন একটু কোডের পর প্রত্যেকটা অ্যাপ্লিকেশন একটা আলাদা অ্যাপিল একসঙ্গে থাকবে, একটা আলাদা ফোল্ডারে। তার অ্যাপ্লিকেশন নাম্বার 1, তার অপোজিশন, তার রিপ্লাই যদি থাকে, তারপর একটা ট্যাগ। গুছিয়ে নিতে হবে। ever.
Appear for the applicant, my lord. First time appearing, contempt, my lord.
I appear in this matter for the alleged contempt, although no notice has been served. But your lordship's order was taken to Supreme Court by way of SLP. However, this order has been passed, so that I should bring to your lordship's notice so that contempt can be dropped.
Exactly.
আমাকে একটা কপি দেন।
Notice served.
Mr. Rai, this is an interim order of modification. So if finally the appeal fails, they will not drop it. We'll postpone it, sine die,
Yes.
or I may liberty to mention sine die or I may die, whichever applies in this matter, because we don't know when that will take. Mr. Rai, did you apply this time? You are conferred. Did you apply this time? Did you confer you, senior gown?
Yes.
Senior advocate, we had conferred you.
Yes.
Yes. Because we are embarrassed often. We say learned senior advocate, and then according to our notions, and then discover that anyway. At the outset, comma, learned senior advocate appearing for the that's mentioned here also.
Yes.
Learned senior advocate appearing for the petitioner places before us an order dated July 21, 2025, passed in special leave to appeal within bracket C number 18392 of 2025, comma, with a copy to the learned advocate for the contempt applicant, comma, from which it is borne out that the Honorable Supreme Court, comma, while admitting the SLP and directing notices to be issued, comma, passed an interim order staying the operation of the.
Notifying your lordship.
But the order was interim.
That's correct.
Acha, very will use the exact. Thereby modifying the operation of the impugned order and directing the petitioner therein, that is the alleged contemptor, to continue to pay a composite sum of rupees 20,000 to the respondent. Full stop. Next para. However, comma, the disbursement of the amount was made subject to the outcome of the petition, comma, thereby the order partaking the nature of an interim order. Full stop. As such, comma, in view of the nature of the order passed by the Supreme Court, which has been made subject to the outcome of the main challenge, comma, the contempt application is adjourned sine die with liberty to the parties to mention for enlistment as and when the SLP is, as and when the special leave to appeal is disposed of, and stroke or any order having relevance is passed with modifying or altering the interim order so passed.
May I just point out two things, man? For my own clarity, my limitations, I understand my
Yes, yes, what?
limitations now. One thing is, my lord, there was a litigation cost directed to be paid.
That
The
has not
impugn
been.
order has been modified by directing to pay that amount.
Only with regard to 20,000 payment. And
Impugn
my lord,
order pertains to the entire order.
and my lord, second thing is
That
there's
is a
no
composite thing which they have been directed.
there's no date mentioned in the I've seen the order. My lord, there's no date mentioned. Whether I'll have to take it up before the Supreme Court.
No, date is there.
No.
Date is there. We refer to the date.
No, my lord. From which date that amount was directed to be, because this was directed to be payable from February.
Impugn order has been modified means it operates from the date of the impugn order at least. So in contempt we cannot go beyond that.
Well, very well.
Have you made ourselves clear? I mean, in contempt you cannot go into that question. At least from the date of the order it has to operate.
Very well. That they have paid.
So as of today we cannot do that.
Very well.
You're paying.
Obviously.
I'm grateful.
Yes, sir. Thank you. Next. Regular learner.
My
What
lord,
happened to your hand?
shoulder got dislocated, my lord.
Yes, what is the matter?
My lord, we had on the last occasion we had we have asked for time because the certified order copies we didn't have them, my lord.
So now
Which-
what?
We still don't have them. We have
You
asked.
cannot indefinitely do this.
I am aware, my lord.
When did you apply for the certified copies?
Just after your lordship had given us the time. However, there was some pen down in Purulia for quite a long period of time, my lord. There was a resolution and nothing could be done, my lord. We will get it. We are supposed to get it this Friday only.
This Friday. We'll keep it a week after that. Learned counsel for the appellant seeks an adjournment in the matter and submits that although the appellants have applied for certified copies of the relevant memorandum of appeal, comma, along with judgments and decrees of both the courts below, comma, no such certified copy has yet been made available to the appellants. Full stop. It is submitted that the appellants have been made to understand that apparently the certified copies would be available by the end of this week. Full stop. Accordingly, let the matter stand adjourned till August 18, 2025, when it will be listed under the same heading to enable the appellants to obtain the said certified copies. 18th August, same heading.
Grateful, my lord.
My lord, I am appearing on behalf of the appellant, my lord. My lord, I am praying for 1 week adjournment as because my lord, death certificate of dead person had been given by my client yesterday, my lord. It is not prepared. My lord.
Substitution application?
Yes, my lord. Only 1 week, my lord.
Let it go out of the list. You file a substitution and mention
Yes,
that those have to be heard first.
Yes.
Learned counsel for the appellant submits that in the meantime, comma, certain parties to the appeal have died, comma, which has been brought to the notice of counsel only recently. Full stop. Accordingly, let the matter go out of the list with liberty to the appellants to mention the matter for inclusion in the list after filing necessary applications for substitution, etc.
Grateful, my lord.
এখন out of the list.
I am for the respondent number 1 to 13.
Respondent.
Yes, my lord.
And appears for the appellant. What can be done? You don't have a right of hearing. It has not been admitted yet.
Yes, my lord.
But on the applications, yes, you may.
Yes, my lord.
Although the respondent is represented through counsel, none appears for the appellant at the time of call. Full stop. Let the matter stand adjourned for the day to enable the appellants to appear and move the matter. You are appearing for the appellant?
Mine.
Yes.
This appeal is directed against the judgment and decree passed by the learned First Appellate Court in Krishnagar Nadia, arising out of a suit for recovery of possession of landed property.
Recovered of possession. You are a plaintiff or a defendant?
I am the defendant, Mama.
Defendant. Suit on ground of trespass or?
Trespass, yes. Disposition, not trespassing, disposition.
Very well.
Forcible disposition.
What was your defense?
A defense that I am in possession for years together, even in the record of rights, my name is recorded, our name is recorded. My father was the original owner of the planted property land. And the plaintiff's case is this, that in the year 1991, Ramcharan Mondal purchased the property from my predecessor in interest.
In the year?
1990.
This is a judgment of affirmance or?
Yes, affirm, concurring judgment.
So 1990 Ramchandra?
Ramcharan Mondal was the purchased the property.
Their predecessor?
Yes.
Yes.
From my predecessor, they purchased it. The plaintiff's predecessor. And in the 2016, Ramcharan Mondal, by virtue of a deed of gift, transferred the same property to the plaintiff. 2016. 2016, by virtue of a deed of gift, transferred the property to the plaintiff. And
plaintiffs?
Yes, to the plaintiff, sole plaintiff. And in 2016 itself, the plaintiff instituted a suit for recovery of possession of the property on the ground that she has been forcibly dispossessed from the property.
Right.
But whereas from the record of right, it transpires that all along, the property has been recorded either in the name of my predecessor in interest or in my name, in the name of the defendants, appellants. Now, the plaint, the caption of the plaint is this. If you want to kindly take up the plaint, of course. The suit is valued at rupees 100. The suit is valued at rupees only 100.
Where do you get the plaint? Annex that?
No, my lord, at that time, my learned junior didn't annex it.
Have you got a copy of the plaint?
Yes, I
got valued at rupees 100. Yes, you get it from the decree.
Yes, judgment and decree.
Rupees 100?
100. And the caption is this, the suit is filed under Order 20 Rule 9. That is the caption.
But
that is not material, but if in a
there a copy of the plaint, both 2 copies of the plaint we are handicapped, sorry. Can't look into that. 100 rupees we can take note of.
Yes.
It's in the decree. Yes, then?
And the ground for recovery of possession is this, they have been dispossessed. They have purchased the property, they have been dispossessed. Now,
even if they don't prove dispersion, then they have title, better title than you.
But the question is this, whether this suit is to be considered under Section 5 or Section 6 of the specific defect.
You are disputing the title.
Yes.
If you dispute the title, it automatically comes under 5.
Comes under 5. Then the title is required to be proved.
Therefore, it comes under 5, not 6.
Not 6. But they have made out a case that they have been dispossessed. And that is why this
can be a component.
That is.
No, the subject to correction by you, I mean, you can definitely correct us if we are wrong. Now, there can be 2 types of suit. One is suit is filed without claiming title, merely on recovery, on disposition. Their disposition is the only criterion. But another sort of suit is there. I seek declaration of my title and seek dispersion. Third category is where I don't seek disposition, but that's incidentally an issue. That also comes under Section 5 because unless title is decided, because you have objected to the title, the recovery cannot be given.
Yes, here the suit was only, the prayer was only for recovery of possession.
There also prayer will be recovery of possession.
Recovery of possession. In that case, if the suit is filed on the basis of title, then the valuation of the property is to be done.
Declaration of title, self-valuation, they can do it.
And there is no prayer for declaration of title.
Not a good ground. So your ground is, what is your ground? That it's undervalued.
Undervalued.
Do you take the point before the courts? For the first time, can you take it?
And apart from that,
you tell us whether you can take it for the first time in the second appeal.
The point of law.
Point of law.
And another point is this, my lord.
Yes.
That the possession, the dispossession is to be proved, since it was an issue. The possession of the plaintiff was decided by both the courts below on the basis of presumption basis of presumption, since they are having a title deed. And the PW1 admitted that the record of rights are still in the name of the defendants.
Sorry. Recorded as
But my lord, under section 3 of the Limitation Act, it is also the onus of the court to decide whether it is barred by limitation or not. Now, the original predecessor in interest of the plaintiff purchased the property admittedly in the year 1990. That is their case. Since 1990, he was not in possession. All along, the possession remains with the defendants, appellants before your lordship. In that case, it was the duty of the court whether the suit is barred by limitation or not. The very fact
you
is
did
there
not
is
take
in
up a
2000
did you take out a point of adverse possession? No.
No.
You took up case of title by possession, title through your predecessor. We'll consider all the questions, but sorry. You've attempted the very best and you have made out all the points that could be made in your circumstance. As you usually do. I mean, the present appeal has been preferred. The present second appeal has been preferred against a judgment of affirmance. Push up. Both the courts decreed the suit for eviction filed by the respondent stroke plaintiff stroke respondent for recovery of possession from the defendant stroke appellants. Push up next para. Learned counsel appearing for the defendant's appellants contends that the appeal should be admitted on several questions of law. Push up. First, comma, learned counsel contends that the suit was valued merely at ₹100, whereas the title of the plaintiff was required to be declared, comma, since the defendant stroke appellants claim possession by title through their predecessor in interest, and their names have been recorded in the records of rights all along, comma, which has been admitted by the plaintiff's witness as PW1. Alternatively, comma, it is contended that the suit, comma, as framed, comma, being merely for recovery of possession without a declaration of title prior, comma, ought to have been construed as one under section 6 of the Specific Relief Act, comma, in which case the suit would be palpably barred by limitation as well. Next para. The question of limitation, comma, it is argued, comma, would also arise in the event the suit is treated to be one under section 5 of the Specific Relief Act, comma, since the alleged title deed executed by the predecessor in interest of the defendant's appellants in favor of the
one Ramcharan Mondol.
Is favor of one Ramcharan Mondol, comma, who was the predecessor in interest of the plaintiffs, comma, in the year 1990 would be the date of commencement of the cause of action for the suit. Push up. Next para. Learned counsel further contends that in a suit for recovery of possession simpliciter, comma, the date of disposition and the particulars thereof had to be proved by evidence by the plaintiff, comma, plaintiff stroke respondent, comma, who was the dominus litis. Dominus litis. Full stop. Next para. In the present case, comma, both the courts have proceeded on the basis of presumption, comma, without any specific evidence being laid as to the date and circumstances of disposition, comma, which also vitiates the impugned decrees as per learned counsel for the appellants. Full stop. Next para. However, comma, we are unable to agree on learned counsel for the appellants on all the counts. Full stop. Next para. First, comma, in a suit, first, comma, there can be two categories of suit, hyphen, one straight away under section 6 of the Specific Relief Act, comma, where the very premise of recovery of possession is only disposition without any claim to title. And secondly, comma, a suit for recovery of possession where a claim of title is also involved. Full stop. The second category of suits can be of two types, comma, a suit in which declaration of title is not specifically sought or prayed for, but in view of the defense case challenging disputing the title of the plaintiff, comma, the question of title has to be decided incidentally, comma, prior to granting recovery of possession. Full stop. In the second category of such cases, comma, the plaintiff seeks straight away a prayer for declaration of title and consequentially, comma, recovery of possession. Full stop. Next para. The present suit is of the second category, comma, where although the relief sought is of recovery of possession, comma, in view of the defense case taken by the defendant stroke appellants in the written statement, comma, the question of title of the plaintiff stroke respondent has been disputed. Full stop. Thus, comma, the question of title had to be necessarily adjudicated prior to grant of recovery of possession due to the questions raised in the defense, and, comma, as such, comma, despite no clear relief for declaration of title having been sought, comma, the title of the parties became a relevant issue, comma, thus bringing the suit within the fold of section 5 of the specific relief act. Full stop. Next para. As to undervaluation of the suit, comma, even in such a suit, comma, if a declaration of title is sought, comma, a self-valuation can be given by the plaintiff, however, comma, subject to an objection thereto being taken by the defendant. Full stop. Next para. The question acquires the character at least of a mixed question of law and fact and is a curable defect, comma, if at all. Full stop. It is well established in law that if an objection as to a curable defect is to be taken by the defendants in a suit, comma, the same has to be taken at the first possible opportunity so that the court can grant an opportunity to the plaintiff to cure the defect. Full stop. Taking such point for the first time in a second appeal is not permissible in law from whichever perspective. Full stop. Next para. Even otherwise, comma, the question of limitation does not arise, comma, since as per the disclosures in the plaint, comma, the question of seeking recovery of possession only came about when the plaintiff was not only dispossessed, but the title of the plaintiff was disputed by the defendants, comma, which came within the purview of the limitation period from filing of the suit. Full stop. Thus, comma, we do not find any substantial question of law involved in the present matter to justify admission of the second appeal. Full stop. Accordingly, SAT 153 of 2023 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2023 is also dismissed as dismissed. Full stop. No orders to cost. Thank you very much. And sorry. Yes. Next.
Milord, attend number. Milord, my senior is not present today.
I can't hear you. We can't
I'm
hear you.
asking for.
Use the microphone. We can't hear you.
I'm asking for adjournment because my senior is not present today.
Who is not present?
Asit Kumar Bhattacharya.
An adjournment is sought on behalf of the appellant.
My lord, I am appearing for the appellant petitioner. My lord, I am appearing by way of, my lord, no objection. My lord, that was already filed. My lord, I am praying before your lordship only 2 days accommodation, my lord, to prepare.
On the prayer of the appellant, comma, the matter is adjourned till
Only 2 or 3 days. Next week, my lord, any date, yes. Your
adjourned till August 11, 2025.
Grateful, my lord.
You give your name also. Both of you, please give your names. Yes. You give you only your name. Where are you escaping? You're for the respondent.
Yes, Milord.
Give your name on a slip of paper.
Oh.
Your name only, not your senior's name. For the respondent, right there. Ms. Dedhaval, please instruct him.
Well, I am for the appellant in this matter, my lord. Noting showing the defective, my lord. I want to cure the defect, my lord, first, my lord.
What are the sort of defects?
My lord, what defect, my lord? I have not seen, my lord.
You are usually very alert in your matters. Why you haven't to checked up?
My lord. If the defect is minor one,
Let us see whether it can be cured by you at all.
My lord, I can remove it.
You will say?
Otherwise, my lord, if your lordship allow me, my lord, I can proceed on.
No, we'll just. As a classification of appeal furnished in words erroneous, you have stated memorandum of appeal from original decree. Appellate decree.
Yes, my lord.
You have to correct
Fine,
that.
I'll-
One. Secondly, certified copy of trial court judgment you not
My
file.
lord, this is a second appeal because my lord, the Xerox copy of the first.
You have to file certified copies of the trial court also.
I will file, my lord. I will come back.
We'll give you a week. Do you have it with
My
you?
lord, kindly give me 2 weeks time. In the
2 weeks.
meantime, my lord, I will come back.
Very well. And name of respondent numbers 2 and 4 to 10 of the decree of the lower appellate court do not find place in the cause title.
My lord, I will check.
Rectify all the defects. We'll
My
give
lord,
you.
I will check it.
On the prayer of learned counsel for the appellant, the appellant, the learned advocate for the appellant is granted leave to rectify all the defects as pointed out by the stamp reporter
My lord.
within a fortnight from date. The appeal shall next be listed under the same heading on August 19, 2025. Section 5 করেছে কিনা দেখেন. Yes. None appears to move the condonation of delay application. Full stop, let the matter stand adjourned for the day. Application এ কতদিনের delay সেই জায়গাটা blank রেখে দিচ্ছি. Main copy. No, 25, none appears to move the matter. Adjourned for the day.
My lord, I'm for the appellant. In the morning, I prayed for a day accommodation.
For a day?
For a day accommodation. But the thing is that when I received the file, on behalf of Mr. Karim, actually he has to leave for, there's a mishap in his family.
When should you keep it? Tell us.
Yes, my lord.
When should you keep the matter next?
My lord, next week actually, because the affidavit in service in one of the battery, number 26 not been completed because till 31st we are receiving the.
Well, on the prayer of the appellant, let the matter stand adjourned till August 11, 2025. Next Monday.
Much obliged. Name required?
Give your name. স্লিপ গুলো ওখানে কয়েকটা একটু বাঞ্চ সব রাখলে উড়ে যাবে তো বসিয়ে দিলে হবে থ্যাংক ইউ স্লিপ গুলো ওখানে বসিয়ে দিলাম
I don't know 27 also. Yeah.
Same order.
Same.
Any other matter which you have forgotten?
No, no.
Item number 28.
Not I beg to appear for the
Yes,
petition.
Mr. Banerjee, nothing in the matter or something in the matter or everything in the matter? What sort of, which category?
My lord, section 5, 4 days delay, my lord. The delay needs to be condoned, my lord. We have served, my lord. Service has been delivered, my lord.
Which is the number of, can 2?
Can 2, my lord.
What is the reason? Formally?
My lord, city civil court, my lord, the learned advocate on record was of the impression that the deal 90 days.
Despite service, none appears for the respondent. Full stop, the affidavit of service filed to be kept on record. In view of sufficient explanation for the minuscule delay of 4 days in preferring the appeal having been made out, can 2 of 2025 is allowed, thereby condoning the delay in filing FMAT 468 of 2024. Full stop, Mr. Banerjee, there's an issue whether we have determination now. Entire FMATs have been given to Justice Shen's. The same problem which arose when Justice Tannen was there. You people had moved the Chief Justice's secretary and it was resolved. Now, the problem is entire FMAT is with Justice Shen. First miscellaneous appeals, exclusive jurisdiction. We have entire Order 41 Rule 11 hearing. But Order 41 Rule 11 is a stage determination, our stage of the appeal. If the subject determination is not with us, we are in doubt. Now, therefore, we have tried to resolve. The Chief Justice, Honorable Chief Justice has not come to court today, but we are trying to resolve. We'll adjourn this matter for a week for a resolution of this thing.
Yes, yes.
Since there is some doubt as to whether this bench has the determination to take up first miscellaneous appeals comma, since the determination of such appeals has been conferred on a different bench, and only the determination as to the stage of appeals, that is Order 41, Rule 11 of the Code of Civil Procedure, has been conferred on us, comma, let the matter stand adjourned till August 11, 2025, till such issue is resolved. We don't want to release it right now because again, if the other bench says, then there will be a ping pong ball. এফএমএটি গুলো সবই আমাদের করতে হবে, যদি না এমনি টাইম হয় তাহলে এগ্রাউন্ড টাইম। এইটা না মেঘনাথ, আপনি একটা টেমপ্লেট করে নিন। Yes. For the appellant, who is for the?
For the appellant, I am.
You're for that. You're respondent. Appeal was admitted? No.
No.
Was a direction to delete a portion of the impugned section.
Impugned?
Impugned order section, since they have challenged the ex parte decree granted in appeal as well as the order passed under order 9/30.
That portion has been corrected.
That was directed to be.
Yes, but we have this determination issue. We'll keep it next week. Same order as the previous one. Since there is
Names, shall I give the names?
Names, yes, give the names. We have passed a formal order.
Respondent Bank.
My lord, Advocate on the court could not come to the court for his severe fever.
Could you keep it?
So not today.
An adjournment for a day is paid for on behalf of the appellant, full stop. However, since বলে ওই আগের অর্ডার থেকে ওটা কোট করে দেবেন। Since determination, we have an issue regarding determination. Let it come up on Monday, next Monday. Give your appearances. Give your appearance. Appearance.
Lord, I beg to appear on behalf of the appellant.
Yes.
So this is second appeal. Weekend, Lord, I have
Defect, what is it?
Lord, I have received instruction to appear for the respondent this weekend.
Let us see whether we.
Well, yes, absolutely.
Acha, preamble is bereft of the name of the trial judge.
But earlier some corrections were reported to be done, which is sent to the Daniel trial court, and again sent back by the Daniel trial court. But I have not gone through the whether that correction has been made or not. But probably the Daniel court.
Acha, there's a revised report. First name of Sola.
Other parts we have come.
Other defects we have removed, right?
Deficit
The revised report says on verification of the rectified judgment degree, the first name of sole appellant in the certified copy of degree on appeal does not tally with the certified copy of decree in trial court. But that's again, certified copy of decree on appeal may be sent down to court below.
That was that has gone.
No, again after rectification. No, that you are not at fault for that. So we'll this is a second appeal.
Yes,
We'll take up for hearing on order 41. If you admit it, then we'll send it back. Otherwise, no question of sending it. Or no question of you giving any copy to Mr. Chatterjee also.
My lord.
Yes.
So let me try, my lord.
Yes.
That the backgrounds of the case is necessary.
Mr. Chatterjee, don't intimidate us by standing.
No.
Yes.
That this is not the earlier the defendant is the appellant before your lordship. This is a suit for dissolution of the partnership firm. But prior not background of the prior story is necessary because not earlier.
Can you please just tell us whether you are the plaintiff or defendant?
Defendant.
Defendant and judgment of affirmance.
Judgment of affirmance.
Achha, very good. So suit for dissolution of
partnership firm and reddition of accounts. That based on there are some earlier litigations. The defendant and the plaintiffs were the partners of a firm named as Rishabh Builders. That was not in 1996. Now, dispute arose between the plaintiffs and defendants. Defendants claim that the plaintiffs number one, Kodavati Tiwari, plaintiff number one, she has retired from the firm in 1998 and deed of reconstitution was made. That is registered deed. Thereafter, the firm was reconstituted in between the Pawan Kumar Tiwari, the son of the Kodavati, and the defendant. Now, it was the claim of the defendant that the plaintiff number one retired and thereafter the Pawan Kumar Tiwari also retired. by giving a resolution, and the firm became the sole proprietorship firm of the defendant.
When did Pawan retire according to you?
According to you, 2007 for 2002.
2002?
Huh? 47 2000. No, no,
Oh,
7 for 2000.
47 2002 আছে
7 for 2000. 7 for 2000.
7 for 2000.
I'm correct. 7 for 2000. Now,
Yes.
my lord, it was the claim of the plaintiff that I have retired. So both this counter case and counter claim is there. Now, they filed a suit.
No,
that
they
is-
denied that Kalavati retired at any point of
they
time.
denied that Pawan
So they say you have retired, so the
so
two
I have
plaintiffs have
withdrawn some
become.
excess money. So I have retired. Their partnership firm has been dissolved, and they continued the partnership firm after reconstitution. That is their claim. This is admitted. Now,
All right.
thereafter, my lord, based on that, my lord, resolution, alleged resolution, they filed a suit in 193 of 2003. That suit was decreed in their favor, declaring that I have relinquished my right of 20% share in the partnership firm, and the plaintiffs, they have got their share is increased 50%, 50%, mother and son. Now the suit was decreed in their favor. That was appealed against. That was stayed by the first appellate court. The first appellate court again affirmed the judgment and decree. It was not asserted before this honorable court in second appeal. Now second appeal, the honorable court set aside the judgment and decree, holding that the suit is not, it is not maintainable because of section 69 as well as on merits also. Now that was challenged before the honorable the Supreme Court. Now in the meantime, based on declaration in title suit number 193, they filed a suit for eviction of licensee, treating me as a licensee, as if I have retired, I have relinquished myself, I am an outsider, so you just evict and quit the property. That suit was decreed ex parte within 90 days against me. I was ousted from part of the suit property in execution proceedings. So, kindly pardon me for giving the background, because this is important here. Now, so the SLP against the judgment and decree in 193, that is the declaration, that was filed by them, it was dismissed on merit. Now the Supreme Court observes that, however, their liberty is given to, they may file suit for dissolution of the partnership firm in accordance with law if the partnership firm at all subsists. That rider was there in the Supreme Court judgment in the SLP. In the meantime,
no, if the Supreme Court affirms the judgment of the second appeal,
where
it was also held that section 69 bar comes in.
No, Supreme Court says that since it was not the declaration by way of partner, by the partners against another partner, it was hit by section 69.
Yes.
And the trial courts, the honorable single bench in this honorable court also affirmed held the judgment on merit. Supreme Court dismisses the SLP, but gives a rider that they may, plaintiff may file suit for dissolution of the firm and rendition of accounts, because that in that case section 69 would not come into play.
Section 69.
Section 69. If
in his individual capacity can file.
No, as a partner, that is also one of my point.
Then the Supreme Court judgment is, with due respect, contradictory.
Absolutely, Brad. Absolutely, Brad. But section 69.
Let us see the Supreme Court order first,
Fine.
and then we'll continue with your arguments.
Absolutely.
Where is it annexed? Somewhere.
My kindly take my stay petition.
Yes.
Supreme Court order is page 172. Of the stay petition. Supreme Court probably said because the Partnership Act says.
We'll just come back in 10 minutes and
definitely.
page again, 175.
172, my lord. Sometimes rider that makes some more complications which that we see 172.
Yes.
We see no reason to interfere with the order impugned. The special petition is accordingly dismissed. Application, if any, also stands disposed of. This order shall not, however, prevent the petitioners from seeking such other relief in accordance with law, including one by way of dissolution of the partnership, if the same subsists and for rendition of accounts.
The previous suit was not for dissolution of partnership.
No. Probably that's why, my lord, the Honorable Supreme Court, my lord, said that for dissolution.
Previous suit was for what?
Previous suit for declaration. Number one suit is for declaration that they are the partners. We have relinquished our right. Number one. Second suit is for eviction of the licensee based on the first suit declaration. And this suit dissolution, registration is not necessary. That's why the Honorable Proviso said if it is for dissolution of the firm. And
so now in terms of this, they have filed a dissolution.
No, now I mean the dissolution has been filed, but the trial court, with utmost respect and humility, my lord, proceeded as if, my lord, the Supreme Court given liberty, but the moot questions, my lord, which was raised in the, my lord, by the defendant before the learned trial court, and there is also admission on the evidence on record that the suit, the firm actually stood dissolved as per their version also in 2002, and they took a stand in the earlier suit that was dissolved, and the partnership continued with the reconstitution with the mother and the son. So now they are contending absolutely contrary after the Supreme Court judgment. My question is, my lord, subject to your lordship's kind consideration, my lord, that kindly comes to just 1 or 2 pages of the impugned first appellate court's judgment. That page 31, that internal page 31. That they were at liberty to file, but the learned trial court, my lord, must consider the idea that whether the partnership sum still subsists or not. That is the, the evidence on record that should have been appreciated. Perspective kindly comes to page 31.
Yes.
That the learned trial first appellate court relies on section 7 and section 109 of the Evidence Act. I'll come to later on. That kindly see this, the quotation part. Paragraph 15.7 at running page 31 of the impugned judgment. Judgment theke bolchi. Running page 31 of the judgment. Certified copy of the.
Yes, we are there.
But at this stage, learned advocate of the appellant vociferously argued and draws the attention of this court towards the initial portion of the cross-examination of PW1, Pawan Kumar Tiwari, showing that PW1 unequivocally admitted and diverged during his cross-examination that he did not find any documents to show that Mrs. Rishabh Builders is still in existence and is functioning. An advocate further draws attention of this court to the following part of cross-examination on PW1 Pawan Kumar Tiwari. I did not find any documents to show that my mother and myself, we are running the partnership firm along with the defendant Jagdamba Singh. This is important. Account of the partnership firm was with PNB prior to 7/4/2002. I used to operate the account solely. In fact, it is fact that after 7/4/2002, there is no account of so-called partnership firm Rishabh Builders. I cannot find any documents in connection with the alleged partnership firm Rishabh Builders pertaining to the post period 7/4/2002. My mother will not depose in this suit. I did not produce any document to show that there is any existence of partnership firm Rishabh Builders after 7/4/2002, or that the firm is still subsisting of the partners of the said firm are the plaintiffs and the defendants. Kindly comes to just one or two pages of the so-called the admissions. Kindly comes to page 180. That is the plaint of that earlier suit. No, this suit. That is the stand taken by the defendant. That is also stated in the plaint of this suit, page 180. Page 180, paragraph 7, middle portion. That Kolavati, who retired from the partnership firm and on the state retirement partnership.
Page 180.
180 of the stay period.
Stay application.
Yes, the plain
paragraph 17 is 180.
Yes, paragraph 17.
That the suit number such and such.
Yes, yes. Suit number, the defendant Jagdamba Singh duly appeared in the suit and contested the suit by filing written statement. In the said written statement, defendant further made out specific case that Jagdamba, not he Jagdamba Singh, but it is Kodavati Devari who retired from the said partnership firm, and on her said retirement, the said partnership firm was reconstituted by and between Jagdamba Singh and Pawan Kumar Tiwari by partnership date such and such, and laterally on such and such, the said other partner Pawan Kumar Tiwari retired from the said firm, and in view of the above, said Rishabh Builders lost his character and partnership firm and became the sole proprietorship. It was a stand by the defendant. Now, what is their stand kindly comes to one findings of the judgment in trial subsequent second suit. But I refer the second suit as the suit for eviction, title suit 48, kindly comes to page 139. This is not the judgment in the second suit, eviction. From the middle portion, the plaintiff states that in view of such minutes of the meeting of Rishabh Builders, the resolution of the meeting and the declaration of Jagdamba Singh that the share of the defendant number 1 is totally extinguished. The partnership deed by and between the plaintiff number 1 and 2 and defendant number 1 is automatically dissolved. So this is their stand that dissolved in then. Thereafter, defendant by virtue of the resolution, plaintiff and 2 became the partners and continued the business. That is now they are taking the absolute contrary stand. And in the evidence on admitted on record, the partnership did not continue in reality by the partners. Kindly comes to two sections. The Ranit Appellate Court relied on firstly section 7. Section 6 of the Partnership Act, as you
Partnership Act.
I have after finishing that, I have reframed the questions for your also kind consideration. But after placing these materials, I'll place that lots of kind consideration. The Evidence Act, section 109 tobacco.
থ্যাংক ইউ আর কেউ নেই এখানে? ও চলে গেল কোথায় ছিল? কাউকে দিয়ে ডেকে পাঠান। না না
kindly take my book.
No, you have to read out from that.
It's also quoted in the impute judgment. Paragraph section 6.
Yes, please read out.
Mode of determining existence of partnership. In determining whether a group of persons
give us half a second. Yes. Let's continue in determining whether
a group of persons is or is not a firm, or whether a person is or is not a partner of a firm, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. Now, this is relied on by the First Appellate Court also. Lord, kindly takes section 109 of the Evidence Act also. But I then readily refer to the page of the impugn judgment where this
seem to continue unless
yes, absolutely.
Proved to be
so the real facts are to be decided. And section 109 of the Indian Evidence Act.
The relationship with a partnership landlord tenant it seems to continue unless proved by the person alleged to have ceased.
But it is their categorical admission that after 7/4 they did not continue. That the partnership did not actually.
109 don't.
109 they rely on. That's why my question of I have framed that the First Appellate Court misconstrued section 6 and section 109 of the Indian Evidence Act.
But they do not say that the partnership was dissolved. They say they cannot file documents.
But
or the account was closed.
Absolutely. But in the judgment, I refer to one observation of this judgment as per their stand at page 139, just before placing that. In their
eviction suit, they have taken a stand that
yes, that their partnership firm dissolved.
Was that judgment of the eviction suit
on record?
Was it exhibited in this suit?
Yes. It was
marked as an exhibit in this suit.
It was there.
Was there means marked as an exhibit in the suit?
Yes, exhibit. So admitted.
How was it dealt with? That
my lord, kindly comes to my lord.
How does the appeal court or the trial court deal
My lord,
with that?
appeal court, my lord, I'm coming.
That
Lord-
judgment must have been dealt with here.
My lord, yes. My lord, I'm just coming. But if your lordship permit me, before that, if I just finish up this 109, just for one.
Yes, yes.
109 said your lordship knows that, my lord, when, my lord, the burden of proof as to relationship in case of partners.
We know what there is. Don't need
Your lordship knows that. My lord, and that was my lord, considered by the first appellate court while my lord decreeing, lord. Now, my lord, kindly comes to this.
No, how was this? What was the exhibit number of this
lord.
judgment in the eviction decree?
My lord,
In the eviction suit, and
My
how
lord,
was
my
it
lord,
dealt with?
My lord, this
Appeal
is
court apparently does not deal with it at all.
internal page 9, the list of exhibits. But all these exhibits were documents were.
Which is that
filed.
exhibit?
The certified copy of the exhibit 8 in connection with title suit number search exhibit U here before the learned first.
This was the eviction suit.
Yes, 48. Title suit 48
No,
is
this was exhibit 8 in that title suit.
eight
What,
in that title suit.
what
and
was exhibit 8?
Exhibit U here, that judgment, certified copy of the judgment.
Judgment of a suit cannot be an exhibit in that suit.
But
Here it says certified copy of
my lord,
exhibit
that
8
is a
in.
plain.
Yes.
That plain that is quoted here in the judgment. That is the plain in title suit number 48, which was exhibited in this is not 193 title suit, thereafter 48. 48, this is the plain. Here in this suit, this was marked as exhibit U.
Exhibit 31 is the certified copy of the plaint of title suit number 48 of 2010. Is title suit number 48 of 2010 that judgment?
Title suit number 48, that judgment.
Have you annexed that plaint here?
Yes, my lord, I have annexed.
You have checked up, that is corroborated by that
Yes,
judgment.
absolutely.
So
But
that is the stand.
I say that, my lord. My lord, I just readily refer to that. Plaint.
You read it out from the judgment.
Yes,
You want to
139.
look into the plaint also.
139, my lord. 139 and judgment and the plain time that saying. The plain starts, 48 plain starts at. Yes, this is.
Plaint starts at page 97.
97. My lord, this is. Yes, my lord. Page 107, subject to correction, my lord. No, this is judgment. Plain. Plain. So that is 193 judgment, it says.
No, rather they say that it was admitted by you that it was dissolved, but they disputed the case.
That is by virtue of that resolution. I said that
They refer to your admission, not their admission. They say, but they say rather they continue to say
that is their stand that I have resigned. I said that
not only resigned, they had disputed and a decree was passed holding them to be 50% joint partners. in the
Yes.
teeth of this declaration that they are 50% partners,
That,
then it is deemed that on the declaration which has attained finality, the partnership continued. If they are 50% partners, then the partnership continues.
that judgment has been set aside, but up to Supreme Court. That judgment declaration that was set aside by the single bench, not honorable in second appeal,
Right.
it was affirmed by the single bench.
Yes.
Supreme Court.
Yes.
Now, the judgment I was
But
showing.
on the ground of section 69.
Section 69 also
even
merits.
then,
Also-
whatever it was a complete
and
set
also on merits, also on merits. That the
Even
resolution-
otherwise, it is
Yes,
it is
madam.
set aside.
Now this judgment.
So you cannot either rely on this.
But
You are
that-
relying on that.
Page 139 judgment page 139 plaintiff states that judgment. Plaintiff states that in view of such minutes of the meeting, Rishabh Builders resolution of meeting, declaration of judgments, share of the defendant is totally extinguished. There stand. And partnership deed by and between the party and defendant number 1 is automatically dissolved. This is number 1. And number 2, these list of exhibits, the Ranit trial could relied on section, first appellate could relied on section 109 of the Evidence Act. Why, sir?
The 109 is there because otherwise you have to prove that.
Madam.
But you are relying on their admission that it
No,
has
and
dissolved.
this is number 1. And number 2, the documents, they say the Ranit first appellate court,
Yes.
these documents were exhibited. The reconstitution, partnership deed and other things, kindly comes to the list of exhibits. Prior to that, kindly comes to the list of exhibits, which is as running page 8. The serial number 24, madam. Resignation letter of, has your lordship got it? Resignation letter of Pawan Kumar Tiwari.
Yes.
Resignation letter of Pawan Kumar Tiwari, exhibit V with objection, dated 8/4/2002. Certified copy of exhibit 4 in connection with exhibit D with title suit number 193 of title suit. The deed number 5148 of 1998. It's a reconstitution deed. I have the copy. Deed was that is reconstitution after retirement of Kolabdi. Certified copy of the essay. So the kindly comes to how the Ranit first appellate court dealt with all these documents. Kindly comes to page 30 of the first appellate court judgment. That from the middle portion, may I just rely? It is also pertinent to add, as your lordship got it.
And how was the question of 69 dealt with?
69 was not dealt with here.
Do you take that
I do,
objection?
but my submission, section 69 is not applicable, while dissolution for rendition. Section 16, that's why I am not pressing that.
Very well.
My case is not that these documents, it is mentioned here, these documents were an initial burden rise upon the plaintiff. Plaintiff at his category admission that it was not continued in reality. Section 6 not complied with. And these documents are furnished by the Ranit first appellate court, did not.
How was it dealt with those documents you were showing us?
Mother, kindly comes to page 30.
We are there, 30.
Mother, it is pertinent to add here that the defendant in support of the contention of the retirement of plaintiff number 2.
Where are you reading from? Page 30?
Page 30 in between, middle portion. The furthermore, the sentence.
Furthermore, yes.
Furthermore, it is also pertinent to add here the defendant in support of his contention of retirement of plaintiff number 2, Pawan Kumar Tiwari, being the partner of the reconstituted firm, had adduced 2 documents before the Ranit trial court. 1, resignation letter of Pawan Kumar Tiwari, and certified copy of exhibit in connection with title suit number such and such, Howda, which are marked exhibit such and such and exhibit such and such, respectively. Exhibit W is certificate of the minutes of the meeting. This is the resignation letter and minutes of the meeting of the reconstituted partnership firm incorporating the fact of retirement of plaintiff number 2. So these documents were already on record, but the Ranit first appellate court realized that I have not discharged my burden. Burden initially rise upon him, but section 109, I have not discharged, and section 67 also I have not discharged. So my case is twofold. Kindly consider there are some, kindly pardon me, there are some.
How did the learned trial judge proceed on this?
Trial judge did not go into in details all these things.
So these were not considered by the trial judge also?
No. documents were submitted, but the trial judge proceeded as if the Supreme Court said that dissolution is maintainable. That's the whole
Yes, you're citing something?
no, just a question of law. I have just suggested.
The question of law, yes, we understand this. Not looked into at all, those.
Yes, yes. But first two will be sufficient. But other questions were whether notice is not required. But I have gone through the judgments. But
6 is of the Partnership Act.
Yes. Oh, I'm sorry. Partnership Act. Yes. Section 6 of the Partnership Act. I'm sorry. But one question, it was vehemently argued, but I subject to lots of kind concern is Section 43 and read with Section 7 of the Partnership Act that says that notice is to be served before institution of the suit. But there is Supreme Court judgment in 63 Supreme Court that says if someone is served, that will be deemed to be the notice. So I'm not taking that point. Question number 3, I'm not emphasizing. Lordship kindly consider question number 1 and 2 and also the question number 4, because it's one point brought here also. The partnership, the suit was filed not as a partners. Affidavit was found by as a partner, as a individual capacity. So that point is also is there. Lordship can you consider these are the questions of
Very well. This second appeal will be heard on the following substantial questions of law.
and
this second appeal will be heard on the following substantial questions of law. 1, whether the learned courts below substantially erred in law in reversing the burden of proof by resorting to Section 109 of the Indian Evidence Act to come to a conclusion that the defendant stroke appellants failed to prove his burden of proving the cessation, CESSATION, of the partnership firm, in the teeth of the failure of the plaintiffs stroke respondents to show that the partnership firm, dissolution of which has been sought, was still continuing, as well as in the teeth of the categorical admission of the plaintiffs in their evidence that the account of the firm was last operated till April 7, 2002, and thereafter there was no account of the firm or there was no document whatsoever to show that the firm operated after April 7, 2002. So, Roman 2 airport. Whether the courts below substantially erred in law and in a perverse manner in overlooking the substantial number of documents produced by the defendant stroke appellant, including the stand taken by the respondents in title suit number 48 of 2010, as well as the resignation letter of one of the plaintiffs respondents from the erstwhile partnership firm and connected minutes, to hold that the defendant stroke appellant has failed to prove the cessation of the partnership firm. Full stop, next para. Thirdly, whether both the courts below proceeded on a misinterpretation of Section 6 of the Partnership Act, coupled with Section 109 of the Indian Evidence Act, in reversing the burden of proof on the defendant stroke appellant, despite the failure of the plaintiff stroke appellants to establish that the partnership firm was still continuing, overlooking the documentary evidence on record to show that such prior dissolution of the firm was admitted by the plaintiff stroke respondents as well as borne out by several documentary evidences. Achha, yes, any interlocutory application?
Yes, madam. I'm pressing that why I say so. Without all along been there is a status quo on the property because they are holding most of the part of this property. And kindly take my stay petition, page 182, 282 firstly.
Stay means that dissolution is stayed.
Yes, my lord. My lord, during the pendency of the appeal, the preliminary decree was also stayed by the first appellate court. That is at page 282.
Yes, what do you say?
Sir, only one thing, Lord, I would just indicate, my lord, this dissolution and rendition of accounts, my lord, are just like a partition suit. My lord, after the dissolution in a preliminary form declaring the shares, my lord, a commissioner is appointed who will render the accounts. My lord, just like in partition suit, my lord, this process on, let a final, my lord, decree on rendition of accounts not be taken place by a final decree. Let that be done. The process, let it go on.
Lord,
Just like in partition suit, what it
Yes,
happens.
what do you say? to
one
that?
more thing, not this.
Same principle as a partition suit.
And in view of the facts, the plaintiffs are holding most of the property. They are going to say, I have averred there.
No final degree will be.
Receiver.
No.
You have not asked for any injunction or filed
Yes,
any
yes, but
application.
I have asked for. They have already not taken steps for.
There is no prayer for injunction.
Yes, in the page 13. Page 13.
Achha, you have also prayed for
Yes,
that?
sir. Stay of the operation of the judgment, the prayer for the
Yes.
proceedings initiated under or
What is the injunction prayer?
Rule 15. Stay of the operation of the judgment with the preliminary dated such and such, and stay or all further proceedings in the for drawing of the final decree till disposal of the appeal.
No prayer for injunction at all. No allegation that they are trying to.
Not there. The allegation paragraph 16 kind comes to.
But you have to make a prayer for
Paragraph
that.
16. But all along been all suits there was injunction for status quo and not
Yes,
to
attempt to
create
create. So you will grant you liberty to modify
say
the
that.
prayer. Yes,
I-
will grant status quo to regarding
Only
both
one
sides.
thing, my lord, to that, my lord, kindly I will object to that, my lord, kindly turns to the impugned order of the trial court. Trial court has appointed a receiver. Over the property, there is a receiver. So, my lord, no question of injunction upon me. Then it's injuncting a receiver who is on the property.
Let us see the.
My lord, kindly takes up the trial court's judgment, the penultimate ordering portion, my lord. Internal page 35.
Appeal court
My lord, trial court.
or trial court?
Trial court has, appeal court has affirmed the trial court. That page 35, and it is ordered that Sri Ashish Kumar Addo be the receiver of the partnership estate.
Trial courts.
Memuta. That
My lord, my lord has got page 35, my lord. So, my lord, there is a receiver on the estate.
No, then we will not grant a stay of operation of the decree, but will restrain the receiver from, although the receiver is not a party here, but will grant you liberty to impede the receiver and will pass an order restraining the receiver from dealing with the property in favor of third parties, Mr. Chatterjee.
yes, my lord.
But
And
that the other portion, as you said,
But
will
let the receiver continue the valuation of the property.
the
and
rest of the
those-
things he'll
But
continue.
one more thing, Lord, kindly comes to just did not open. All these suit in 1998, 193, this honorable court passed an order of status quo not to create third party interest. Here.
That is why you are restraining the receiver from doing that.
My lord. And in the meantime, is the judgment is
During
not-
all this period, receiver was not there.
yes, after after this decree, but my lord,
We can restraint on the parties won't help because parties are not in possession.
that's true.
We
No,
will
but
pass a restraint.
party in possession.
A person not in control
Sim-
because the receiver is in control.
Symbolic. And my lord, one more thing, my lord, this has implications on the another suit where my lord, I am claiming not I'm the whole sole proprietor that is pending. So if your lordship kindly do not stay, that will have an impact on that my lord, appeal.
No, we cannot impact that suit. You
My
can ask for whatever relief you know what relief to ask for there.
My lord,
Once we admit this,
my lord, in the prayer, my lord, I have stayed. My lord.
we cannot stay a different suit from this.
No,
but
not this.
Whatever
different
will be the implications, we'll say
But
that all.
yes, in this application, my lord, I have prayed for stay of the operation of the judgment, impugned judgment. That was also judgment stayed by the first appellate court. So, my lord, to maintain consistency, my lord, so that
The
the further-
receiver has not assumed charge till date.
Yes.
no, that my lord, they have filed an application. Only filed an application, not taken charge. My lord, only filed an application under Order 20, Rule 15, reduced
Subject to
151.
correction, my lord,
Page
my
13.
impression the receiver has acted upon.
No, my lord.
No, how do you know that?
No, this is not appeal since the appeal is pending with your lordship. But no further steps have been taken. Only they have filed an application.
Your application is pending.
Only application is pending.
application for what?
That this order 20 rule 15 application ready with 151.
Where is that? That is for drawing up of a final
Final
decree.
decree. No further steps. We have not taken steps. No further steps.
How do you know that? Have you stated
But that is
anywhere?
my instruction. Kindly see their letters.
So that's
They
why
have
I mean, it's a
communicated
form of partition suit, my lord.
No, then the receiver will not take steps. Will stay the operation then. If it was stayed all along, Mr. Chatterjee.
My lord.
If it was stayed all along the operation of the decree during the pendency of the appeal, then when did the receiver take charge of the property?
Well, kindly see, this is their communication. This is
it?
their communication, my lord.
You read
By
it
the-
out for us. We won't look into your mobile.
Lordship ka phone number.
You read out, read out.
Yes, my lord. They just filed an application under order 22 rule 15 for drawing up the final decree of dissolution of the partnership firm.
That is a different thing.
No further steps. Nothing was
So
communicated.
that's why I say, my lord, kindly let us, my lord, deal with this, because what happens, my lord, today, my lord, I am in half-hearted instruction with regard to receiver, my lord, question which fell from, my lord. And my lord, furthermore, this is kind of a partition suit nature. My lord, so even if valuations are being done, because my lord
no
knows
accounts after 7
if 40, 40, 20 has to be distributed,
many properties have been sold
then
by
my lord, the valuation of the estate has to be done. My lord, thereafter, my lord, selling and everything will come into picture.
আচ্ছা এটা বাকি যেটা হাফ দিয়েছি অর্ডার তারপর থেকে বাকিটা কন্টিনিউ হবে একটা অ্যাডমিশনের অর্ডার দিয়েছি সেটা পেয়েছেন আপনি ওটা আপনি আছেন তাহলে আপনি কন্টিনিউ করে যান না উনি কন্টিনিউ করে যান এই অর্ডারটা আপনি নিয়ে নিন correct the present application has been filed for stay of operation of the impugned preliminary decree first up in the application comma averments in support of a prayer for injunction have also been made. First up, on the prayer of the appellant, comma, leave is granted to the learned advocate on record for the appellant to carry out the necessary amendments to the prayer portion of the application by introducing the prayer of injunction as well. First up, next para. Upon hearing learned counsel for the parties will direct affidavits. Upon hearing learned counsel for the parties, comma, we are of the opinion that unless interim orders are passed as indicated below, comma, the appeal might be rendered infructuous. Push up next para. The learned trial judge shall proceed with the final decree proceedings, but shall not draw up any final decree till disposal of the application. Push up next para. Insofar as the portion of the impugned decree which confirms the appointment of a receiver, comma, the same shall remain stayed till disposal of the application. Push up next para. However, comma, it is made clear that in the event the receiver has already assumed charge, comma, the acts already done by the receiver in terms of the impugned decree shall not be affected but shall be subject to the outcome of the present appeal of the present application. Full stop. Next para. The receiver shall remain restrained by an order of injunction from dealing with, comma, encumbering and or transferring the property, subject property, sorry, in favor of third parties in any manner till disposal of the application. Full stop. The respondents shall file their affidavit in opposition to the application within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Full stop. The application shall be listed for hearing next on September 2, 2025 for hearing.
And I also have a copy of the application.
Yes, my lord, copy we have not received
A copy of the application be served on the a copy of the application along with a copy of the memorandum of appeal shall be served on the learned advocate having instruction to appear for the respondents during the course of the day.
Obliged, deep.
Thanks.
I believe my learned is appearing for the respondents. Other round of application, he once said I appeared, thereafter another counsel came.
No, you just check up which of the respondents you are appearing.
Two respondents, my lord.
Both.
Both have given a wakalat.
So you're not directing service on anybody
No,
else?
no, I'm happy.
I'm not obliged. I'm deep.
হ্যাঁ এইটা না ওই আগের ফাইলটা Sorry, yes.
My lord, I'm appealing from the respondents, my lord. My lord, in this matter, my lord, the respondent number 2 has expired, my lord.
No, give it to him actually.
I'm supplying a copy to my lord.
So you have to take steps. You are appearing for which of the respondents?
Both the respondents, my lord. Respondent number 1 and 2, my lord.
2 has died.
My lord, respondent number 2 has.
Learned counsel appearing for the respondents submits that the respondent number 2 has died in the meantime. First up, the particulars of the heirs and legal representatives of the deceased respondent and the date of death of the said respondent. You have already handed over.
My lord, I have only handed over the death certificate.
Shall be handed over by the learned counsel appearing for the respondents to his counterpart appearing for the appellants during the course of the day. First up, the appellant shall take steps, appropriate steps for substitution. In the meantime, first up, let the matter go out of the list for the present with liberty to the appellant to mention for enlistment as and when such substitution application is filed.
No, one thing, Lord, the adjudication proceeding is also going on, Lord.
Nothing doing unless in the name of a dead person you cannot do anything. It goes out. Whenever you file the substitution, give a copy and mention. We'll take it up. Mention the applications, we'll take it.
But in item number 33, my lord, Mr. Shonak
Can't hear you.
My lord, in item number 33, my lord, Mr. Shonak Bhattacharjee.
Take it towards you.
Mr. Shonak Bhattacharjee is appearing, my lord. He is engaged in a
You have grown old enough.
No,
Move the matter. What is the matter?
106 notice.
On the prayer of the appellant, let the matter stand adjourned for the day. On the prayer of the appellant, let the matter stand adjourned for the day.
My lord, I appeal for the appellant, my lord. The list, my lord, it is showing as defective, my lord. I don't know, my lord, what.
No, you properly use the microphone. Either the microphone is not functioning or you are not using it properly.
The list, it is showing in the bracket that it is defective, my lord. I don't know what is the
Defective. You should have checked up then. Why didn't you check up? We used to check up in the morning, first thing in the morning. You please delete this date of decree in the preamble of the appeal. Date of the judgment is the date of decree. And decree dated such and such, dated such and such will be deleted. Apart from that, আর কি আছে? আর একটা হচ্ছে trial courts degree. Trial courts degree file করনি নাকি? Trial courts judgment and degree have not been filed.
That has been filed, my lord, in the along with the memo.
Yes?
Along with the memo, my lord, it has been filed.
No, only appeal court. Only appeal court. You can check up our brief. No trial court certified copy. Unless you file that, the stamp paper cannot check.
Maybe
Xerox copy is not permissible in. It's not in form. We cannot take up order for 21 hearing. How soon can you file? It will give you some time.
Certified করে file করেছেন trial করে
Learned counsel for the appellant is learned counsel, the learned advocate for the appellant. The learned advocate appearing for the appellants is granted leave to carry out the necessary correction in the preamble of the memorandum of appeal, comma, by deleting the date of the decree. Full stop. The learned advocate for the appellants shall also furnish certified copies of the judgment and decree of the court of first instance within 3 weeks from date. Full stop. Upon those being furnished, comma, the department shall furnish a revised report in that regard. Full stop. Let the matter go out of the list for the present with liberty to mention for inclusion in the list as and when the defects are cured.
My lord,
In the meantime, if an opposition.
my lord, in my copy, my lord, trial court's decree is here, my lord.
In my copy, my lord, trial court's decree is here. Judgment and decree.
What is there?
Trial court's judgment and decree.
Certified copies. Don't you know the difference between a photocopy and a certified copy? Are you to believe that? You are moving in the highest court of the state.
No, my lord, I don't know whether certified copy is the next, my lord.
We said it is not there. If you don't believe us, please check up the file.
My lord.
We have seen it. We don't move matters like you. Don't pass orders like you. That you are for the advocate for the appellant. You don't even care to check up the defects which are there. First of all,
I beg your apology, my lord.
please check. No. Akbar file ta dino na ke. Please check up where is the certified copy of the trial court judgment and decree. Show us. We'd be happy to know that it is there. Please check up the memo, the main memorandum, and show us the certified copy of the trial court judgment and decree. Your all-knowing junior seems to know that it is there. His omniscience cannot govern the court.
I beg your lordship's apology, my lord.
So do whatever. Acha, arekta line add kore din. In the event the aforesaid directions are not complied with, comma, within the stipulated period, comma, let the appeal be listed under the heading Lawazima for final orders. Thank you.
My lord.
Next.
My lord, there is an application, my lord. We want to file an opposition. In the meantime, first let the matter be admitted.
There's a joke. It's known as artificial intelligence versus original stupidity. Don't want to refer to that. But if you have not admitted his appeal, you are practicing for quite some time. You are not a raw junior. If you direct you to file affidavits to their application, that means it's a deemed admission of the appeal, sir. If you want that, you can admit the appeal and formulate the questions. It will take half a minute of creativity for us to formulate a question of law. Next.
If we have filed an application for condonation of delay.
Yes, Mr. Mukherjee, have you
10 days delay.
you directed to serve copy? No.
No, this is the first time Lordship have been
Directed to serve copy. The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondents, indicating that the matter shall be listed under the same heading on August 18, 2025, comma, when an affidavit of service to that effect shall be filed by the appellant. Bas. Yes.
Lordship, I am the Lordship, the defendant's appellant.
Defendant's appellants, right.
Now
What is the defect? Let us check up. Since advocates don't have the time, so judges have ample time. So we can check up the defect. So Mukherjee, you are an established chamber. I mean, it's unimaginable. We don't want to refer to past days or our days or something ridiculous like that. But even nowadays, so many people check up the appeals. At least find some time. Your juniors, apart from checking their phones, they should also sometimes come up to the court and take the little trouble of just checking up the back sheet of the first page, reverse page of the appeal to see at least what is the defect. The judge has to find out every time what is the defect, then advise you on what to do, and sometimes hear your advice so that you don't harm your own client. And then we have to look into what law is involved, and then to decide whether we should admit or dismiss the appeal. Now this task is becoming arduous for us now. Now one day will come when the court will directly dismiss the appeal for the defects. That day is coming soon, we are telling you. Because we are not supposed to do these things. You have to point out the defect at the outset, Mr. Mukherjee.
I'm sorry.
This is only a small defect. You should have first asked. The name of the presiding judge is not there. Do you know the name of the judge here? Yes, it's there in the certified copy itself. Should have just put it in the memorandum. And is this a first appeal? Misappeal.
Misappeal.
So the judge's name is there in the memorandum. Do it. You can move the matter, Mr. Mukherjee. একটা লিখেন ওখানে বসে লিখেন এটা ছোট The learned advocate on record for the appellants shall rectify the defect as pointed out by the stamp reporter by introducing the name of the learned trial judge in the preamble of the memorandum of appeal during the course of the day. Full stop. এর বাকি অর্ডারটা কন্টিনিউ করছি অ্যাডমিশন হিয়ারিং শুনে এটা থাকে বাকি অর্ডারটা শুনে নি ডিসমিস করে এর সঙ্গে অ্যাড হয়ে যাবে বাকি Yes, Mr. Mukherjee, what is it?
Lordship, the plaintiff, Lordship, the claim as filed this suit for declaration of title that he is the tenant of the suit property. Lordship, so far the declaration is concerned, he is a tenant, I am admit. This point I admit he is a tenant. Now, Lordship, the building is a very dilapidated condition. Lordship, in terms of section 411, Lordship, the building was about to demolish. Now, Lordship, in terms of this Calcutta Municipal Corporation Act, Lordship, there is a provision of rehabilitation of the tenant. Lordship, we are also ready to give this rehabilitation. But Lordship, without considering all these things, Lordship, he has obtained an injunction order from the learned court below. And entire construction has been blocked.
Anybody appearing for the other side?
No, Lordship, I lodged the caveat. No,
We'll direct affidavit, we'll admit the appeal, we'll direct affidavits, and then it goes to Justice Sen. The other bench has determination for hearing. We have only for. An arguable question has been raised. An arguable question has been raised inasmuch as whether the learned trial judge erred in law in granting a blanket order of status quo with regard to the suit property in a suit filed by the plaintiff stroke respondent for declaration of tenancy right and consequential injunction, without considering the condition of the present property and the dilapidated nature of the same, which is alleged by the defendants stroke appellants. Full this appeal is accordingly admitted and shall be heard on the above questions and on the grounds as taken in the memorandum of appeal. Full stop. Next para. The plaintiff stroke respondent shall file affidavit in opposition to Can 1 of 2025 within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Liberty to mention the application for hearing before the appropriate bench having determination after the above timeline is over. Bas. ওই যেটা আগের অর্ডার পার্টটা দিলাম যে কারেকশন করবে তারপর এটা ঢুকে
মুখার্জি এখানটায় লিখবে
না এই এবার রেগুলার বেঞ্চে অ্যাপিয়ার করবে সার্টিফিকেট কপি
passed by the learned
থ্যাংক ইউ ঠিক আছে
Lord, I'm sorry, Lord. It ought to have been looked into by
Yes, expected at least from chambers which have established practice. Both you and the learned counsel for the respondent. If it was him, he would have been reviewed the same way. Yes. Next. 37. D মানে কি?
My lord, there were certain defects, my lord. All the other defects were cured that very day, my lord. But only one defect, the trial court judgment and decree was not there, my lord. Old suit and the Xerox machine of the learned trial court certified copy department was not working, my lord.
Now it's working.
Now it is working. I am to get the certified copy tomorrow, my lord. I am told kindly grant me 1 week time. I'll supply it and
only thing, my lord, the corrected memorandum of appeal, my lord, was directed to be served upon.
Oh. Learned counsel appearing for the which respondent you are appearing for?
Sole plaintiff respondent.
Very. It is submitted by learned counsel for the respondent that no corrected copy of the memorandum of appeal has been served on the said respondent. First, no corrected copy of the corrected memorandum of appeal has been served on the respondent. Full stop. The learned advocate for the appellant shall serve the same on the learned advocate for the respondent during the course of the day. Full stop. On the prayer of learned counsel for the appellant, appellants, plural, appellants, in order to file the certified copy of the judgment and decree of the trial court, the matter is adjourned for a week and shall be listed next on August 11, 2025, by which time the appellant shall file the certified copies of the trial court's judgment and decree.
My lord.
Yes. ঠিক আছে। Next. Give your names, both of you, all the matters. Yes.
38, my lord, I am for the appellants. Led by Mr. Tanmay Mukherjee, I am praying for adjournment, my lord. And
Why?
defect, my lord, classification of appeal is not. I shall remove the same.
Thank you. At least in one matter, somebody went through the defect. Leave is granted to the learned advocate for the appellants to rectify the defect by this is original order.
My lord,
By rectifying the rectifying the defect by amending the classification of the appeal in the memorandum of appeal by August 5, 2025. Full stop. The matter be listed under the same heading on August 6, 2025.
May please your lordship, I am appearing.
I'm appearing on behalf of the respondent.
Section 5.
Section 5, my lord. This
What is
is
the
out
delay?
of time. 120 days delay.
What is the explanation?
So far as my lord explanation is, so far as the plaintiff has preferred appeal before the learned district judge, and according to the Bengal Agra Assam Civil Courts Act, my lord, that appeal is not maintainable so far as under the pecuniary jurisdiction of the. This is the suit value of rupees 3,81,000. I have explained, my lord, in paragraph number 4.
There are several other defects also. Name of the presiding judge is not there. We'll grant you leave. Name of the presiding judge of the trial court is not there. And classification of the appeal is erroneous. What is this?
Well, this
Against
is an
what?
appeal against the rejection of the order passed under Order 39, Rule 1 and 2 by the learned civil judge senior division Paschim Midnapur.
Rejection of an
rejection of the application under Order 39, Rule 1 and 2.
in the suit itself. In the suit itself.
No, not suit itself. Suit is pending.
Oh, the rejection was in connection with the suit, not an appeal.
Not an appeal.
So in the memorandum, you have to correct the classification of the appeal. Please do that. And you have stated memorandum of appeal from original judgment and order.
Judgment and order. Only
just
judgment.
original order. Judgment and that's go through that and this
Just order. Order
just order and then the name of the learned trial judge you have to put in.
Name of the learned trial judge.
Passed by such and such, name of the judge you have to put in. Do you don't know the name?
So, my lord, kindly see
Even
the
order
order
is-
number 2.
It's in the impugned order, so do it right now.
This is
Very well, let us hear the.
order.
Do you understand what you are saying? Two defects. One is the classification of the appeal, which you have understood, and the name of the learned trial judge has to put in the preamble of the memo. Do that during the course of the day. We are granting you leave. We are hearing this section 5 now. So you said 120 days delay
120 days delay.
because you preferred appeal before a wrong forum.
Yes.
Yes, what do you say?
Lordship, I have no objection so far.
Thank you. Heard learned counsel for the you are for defendant number 1.
Lordship, defendant number 2, your lordship.
One,
I am
what
for
about
the
service?
appellant.
One has to be served.
One has to be served.
Lordship, I apologize. I'm for the
Well, I
defendant
have-
number 1.
You have
My
to be
lord, I
for
have
one.
filed
Yes.
affidavit of service on the last
Both,
occasion.
both have been served. Very well. Despite service, none appears for the defendant number respondent number 2, although the respondent number 1 is represented through counsel. Full stop. Upon hearing learned counsel for the parties, we find that due to a bona fide error, The appeal was previously filed before the learned district judge, comma, despite the pecuniary valuation of the same, demanding that the same be preferred before this court. Full stop. Upon detection of the error, comma, the present appeal has been filed. Full stop. In view of there being bona fides involved in such technical error on the part of the appellant, comma, who was represented by an advocate in the courts below, comma, can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT number 199 of 2025. Full stop. There will be no order as to costs. Yes, what is the appeal about? Appeal is a misappeal. Now, miscellaneous appeal, we don't know whether we have determination to hear now under order 41. Since since there is a doubt as to whether this court at present has determination, doubt as to whether this bench, comma, as of now, comma, has determination to take up first miscellaneous appeals, comma, at any stage, comma, including the stage of hearing under order 41 rule 11 of the Code of Civil Procedure, comma, let the matter stand adjourned for a week till August 11, 2025, till the said dispute is resolved. Come back on next Monday. Although you should not have allowed ideally the section 5 also. But because you are at present, we have just allowed that. Entire subject matter misappeals has been given to Justice Shane's division bench. We have order 41, which is a stage of the appeal. But if subject determination is not given, whether we can take up the order 41 hearing, we don't know. Yes.
Next.
Continue after the recess. হ্যাঁ একটা গন্ডগোল রয়েছে। হ্যাঁ হ্যাঁ, থ্যাংক ইউ। আপনি ওটা নিজে টেস্ট করে নেবেন যদি দেবেন। থ্যাংক ইউ। ইয়েস।
My lord, I am appealing for the appellant. This matter is wrongly filed before this court. Your lordships.
Please use the microphone. Yes.
Matter is wrongly filed here before this court. Your lordships, order passed by the junior division, civil judge junior division. So your lordships,
The valuation of that. Valuation you have not even given. Very well. Learned counsel for the appellant submits that junior division and Learned counsel for the appellant submits that the appeal has been preferred erroneously before this court and that the appropriate and that this court does not have the pecuniary jurisdiction to take up the appeal. Full stop. We find from the memorandum of appeal that the order of a learned civil judge (junior division) has been challenged, and as such, it is quite obvious that this court does not have pecuniary jurisdiction. Full stop. Accordingly, FMAT 245 of 2025 is dismissed as not maintainable before this court, with liberty to the appellants to prefer an appeal against the impugned order before the appropriate forum / court. Full stop. The learned advocate on record for the appellants shall be at liberty to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. Can 1 of 2025 is consequentially disposed of, no address to cost. You can take back the certified copy by putting it in.
Lord, I am for the appellant petition.
Section 5 has been filed.
Lord, filed. It has been filed.
This is appearing for the first time. Section 5.
First time.
We'll direct you to serve and come back. Serve both the applications.
Lord, my learned friend has already served. Lord.
Cannot look into if you know the law. If they appeared, we could take up the matter. The appellant shall serve copies of both Can 1 of 2025 as well as Can 2 of 2025 on the respondents, indicating that the matter shall be listed under the same heading on August 18, 2025, when an affidavit of service to that effect shall be filed by the appellant. Clear.
Your Lordship, I appear for the appellant in this matter. Your Lordship, there is a Section 5 application. My Section 5.
First time.
Yes, Your Lordship.
The appellant, one appellant. The appellant shall serve copies of Can 1 of 2025 as well as Can 2 of 2025 on the respondent, indicating that the matter shall be listed under the same heading on August 18, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Great. Oh, Chaudhary. Sorry.
My lord, I appear for the appellant in this matter.
43, this is order 41 hearing.
Yes, my lord, but I am told by Mr. Banerjee that I am challenging 11 June 25 order. There has been a subsequent extension of the interim order. In view of the law, which is, my lord, it's still pending before the larger bench. So, my lord, I have to possibly, my lord, file.
So, when should you keep it? My
lord, I can file it next Monday, lordship may keep it. I can file it by that time and I can come back.
So very well. Learned counsel for the appellant submits that since the present order has been preferred against an ad interim order, which has subsequently been extended, the appellant intends to prefer a further appeal against the extension order. Full stop. Accordingly, on the prayer of the appellant, the matter is adjourned till August 18, 2025. Full stop. Leave is granted to the learned advocate on record for the appellant to mention the prospective appeal, as and when filed, for enlistment along with the present appeal in the meantime. Whenever you file that or file any application in connection with that, give a slip so that we can tag that along with this.
Right.
And indicate in that slip just to be heard along with this.
Kindly permit my advocate on record to enter an appearance here.
Yes.
I don't have a caveat. I don't have a caveat.
Your name will be recorded.
My lord, so far as the extension is concerned, my lord, only a memo of appeal would do because.
Oh yes, right.
My
You're
lord,
right.
my application is there.
So just mention that appeal number and we'll
This
tag.
appeal number and yes, great.
Name tag to the area.
is my appeal, Your Lordship.
What is the defect?
There are two defects. One,
It's
Wakalatnama
only
has
the
been-
second appeal of the day that somebody has checked up the defects. Thank you.
two defects. One is that original order in the memo of appeal is not mentioned, and the Wakalatnama has been filed with the memo of appeal and not stay petition and not with the memo of appeal.
That we can, the second one we'll deal with.
And the first one also, I have to just make an error endorsement that original word is missing from the memorandum.
No, and not the day order dated such and such and all.
Nothing, nothing. Only the expression original.
Memorandum of appeal from original order. This much will be there. But rectify the things, but we require at least 1 week time to seek a clarification because FMET determination has been given to different bench, Justice Sen's bench. And subject matter jurisdiction, we have only the state jurisdiction. So we'll keep it on Monday. We'll say that. We'll give that as the reason. In the meantime,
Kindly keep it on Monday because I'll also indicate I have cost services, but the postal speed post is down.
No,
So-
the difficulty is unless we direct you to serve,
Yes.
that service has no effect in the IOL.
Right.
Unless they appear and we take their appearances.
I wanted because if I may permit,
Urgency.
I'll indicate. I filed a suit in 1999. It's a suit for cancellation and declaration of certain shares. I was enjoying certain interim
No, the
orders.
difficulty is otherwise because we are substituting these directions for postal service for the rule which is still there in the appellate side rules.
Right, right.
So now, unless we issue a rule after admitting the appeal, that cannot be taken cognizance of. If they appear, then we take it that they are appearing in the matter and then we record their admission.
I
So
only
we cannot take your affidavit of service.
I agree. I only want to cause service on the trial court lawyer because I'll indicate the difficulty. It's a peculiar
We
circumstance.
can't give you that leave. We can't give you that leave because we are not sure whether we have determination even today. But we'll direct you to rectify the errors in the meantime. Learned counsel, the learned advocate on record for the appellants shall cure the defects as pointed out by the stamp reporter, comma, in the memorandum of appeal within a week from date. The matter shall be listed on August 11, 2025.
Because a classic case, my suit has been abated. I saw declaration that who are the legal heirs because the defendant disclosed that one defendant passed away. I indicated, please supply me the heirs. The trial court has made my entire suit dismiss and abates.
Dismiss as?
Dismiss
Abated.
the suit as abated against all. And I have filed this application asking for the declaration that who are the legal heirs on record. And the moment the suit goes, my interim order, which I was enjoying, that's also going on.
No, the court has to come to a finding at least who has died and when he has died.
Your Lordship, in my case, a co-defendant has indicated one ex-defendant passed away.
No, the court has to be satisfied that he has actually died.
He has indicated there is a specific order of the court directing him to please furnish information. I also make an application, please furnish information. The trial court passes.
You have
an
already served if they take, if you are in luck, they'll appear. So if they appear, we can take the
That
note
is
of
the
their-
reason because I was trying to contact trial
We
court
did that
lawyers.
all the time. But if they don't appear, then if they also know this thing, this trick, then we'll have to.
Because I know, because my interim order is uneffective. That is the only difference.
Cannot
Grateful.
pass it.
I'll correct the defects, Your Lordship.
No, we can pass ad interim if you admit your.
Your Lordship. Okay. Today.
No.
Next. On 7th.
We don't know whether we have determination today.
I'm praying for my luck, Your Lordship. Okay. Grateful, Your Lordship.
যেটা none appears for the parties, let the matter stand adjourned till August 11, 2025.
I pay for the appellate.
Totally, we are not sure whether we have determination today to take up order for regarding misappeals. Since this court is now, since the determination for hearing first miscellaneous appeals has been exclusively conferred upon a different bench, comma, there is some doubt as to whether this bench has determination to take up even hearings under Order 41 Rule 11 of the Code, insofar as the same relates to miscellaneous appeals. Footstep, accordingly, let the matter stand adjourned till August 11, 2025 for a resolution of the issue in the meantime. We'll try to resolve that.
Grateful, man.
Thank you.
My appeal, my lord.
Same order. Same order. Come back next. And we are sorry. I mean,
No, Monday.
it's Monday. In 1 week, this will be resolved.
Very well.
We'll have a talk.
Item number 48, Lordship, and for the appellant, I am led by Mr. Shobhashati Chatterjee. By the time he comes, I'll carry on with the.
No, don't carry on. We don't have determination probably today. Since same order, আগেরটা যা হলো, determination. Next Monday.
49, my lord, I'm appealing for the appellant in this
Mr.
matter.
Chatterjee, same order.
I understand.
Same order. Same. না 50টা অন্য করে দাও 50টা করে দাও none appears for the parties at the time of call. Accordingly, let the matter stand adjourned till August 11.
51, my lord, sorry.
No determination order. এটা no determination টা
Matter, Mr. Anindo Haldar will appear. He is on his leg, Lord. So I'm paying for short passover only.
An adjournment is sought on behalf of the appellant. Let the matter stand adjourned till August 11. We have granted a very short adjournment of a week. Yes. None appears for the parties at the time of call. Adjourned till August 11. Same. None appears. None appears. August 11. Same. Passover. Passover. এগুলো Passover করবো এগুলো যদি সেকেন্ড কলে আসে করে শুনে দেবো পাঠ Passover.
57, my lord, I'm
Good afternoon.
appealing for the respondent. My lord, this argument was over, my lord. My lord directed us to file our written notes. But, my lord, on the last occasion, the appellant appearing Mr. Saurabh Sen, my lord, he prayed for a few minutes of time, my lord. He wants to, in a reply.
But did we take on record your written notes?
No, not yet.
Because of that.
Because of that.
Intimate Mr. Shen if you can come. I mean,
Well, my lord, because this is that probate matter, my lord.
Yes.
That
half-heartedly recall. But Mr. Chatterjee, if he comes and argues, I mean, we are open because we don't have matters otherwise.
Yes,
FMAT we won't take up today and then.
None of us apprehended, my lord, would reach.
No, we did not apprehend. Well, coming to court, actually, I looked into the list and then suddenly struck that entire FMAT determination somebody else has.
Yes.
We are, strictly speaking, we are left with the residuary order 41 jurisdiction. That which means only second appeal. Because nothing else remain. Yes, but those no. All other appeals are FMAT. SMAT, if it's an SMAT, yes, we can have returns. Yes, Passover. We are passing it over, Mr. Chatterjee. If somebody can inform,
I shall inform Mr. Sen.
through somebody do it. You remain in court. If you can start the matter. এখন Passover থাক কল করুন Passover. Passover. You are appearing?
Item 60.
60. We are passing over this matter. 60 you are ready. You can do the matter right now.
No, but my seniors are there.
He's coming. So we'll call the Passover matters.
Yes.
Passover 57 থেকে করেছি তো 57 টা কল করুন
Pass it over for our.
Mr. Chatterjee, yes, ফাইলটা দেখি You will be reminding us of them.
Yes.
Mr. Shen's junior. That was Mr. Shen's junior.
No, he's my
Your junior.
Mr. Oyan Banerjee was also appearing, my lord, for one of the respondents.
No, we recollect the that you were appearing, you people were appearing, but the merits we have in between several death references and criminal bills and GST matters have interfered. Yes.
But, quickly recapitulating, my lord.
What was the matter about? Just recapitulate. I mean, we'll recapitulate so that Mr. Shen
Yes.
thinks that it's on the board, so it must be going on, and he comes.
What happened, item 52, the reason why I missed is extremely bad, my lord. We were looking at code 16. And
No, we have a tendency even now sometimes to, I mean, go up.
so my clerks were following, it was 19.
Right.
So no.
Weren't you surprised that it was 19 till now? Anyway, needless not.
My lord, I tell you, Lordship, my lord, it's an appeal, my lord, challenging, my lord, a grant of probate.
Yes.
Now, my lord, what happened, my lord?
You are for the appellants.
I'm for the appellants. No, my lord, I'm for the respondent.
You're for the
Mr.
respondents,
Sen
yes.
for the appellant.
Yes, Mr.
Now, my lord, what happened, Mr. Sen's argument was, my lord. Oh,
yes. Yes, Mr. Shen, what do you have to add? You have to add something there.
Can you take it tomorrow?
No. We don't do. We are short of matters and we are workaholics.
Actually, my brief is
We have an addiction to these appeals.
But only thing, my lord, I
We
want
cannot
to,
live without hearing an appeal a day.
but just pass a short pass over.
This is the second passover you're doing.
I understand, my lord. Well, just short pass over.
Your files will be coming.
My lord.
Definitely, yes. So very well, semi-short passover.
10 minutes.
Yes, that is what we are thinking also. Mr. Chatterjee also pointed out. We can wait for a few seconds so that there's a pressure on your clerk to bring the file quickly. It's on. It will be on the board, so he'll be seeing that the matter is going on. That is the way we brought you here. Let that apply to your clerk too. It's in your chamber, in your bar association room or car. Car. All right. Passover পরেরটা দেখো না। এটা থাক সাইডে থাক এক্ষুনি হয়ে যাবে পরেরটা হবে না। দেখি ফাইলটা দেখি। দিব্যেশ শাস্তি তো কোর্টে ছিল। অন্য ম্যাটারের জন্য শাস্তি ছিল। ফরসামত ছেলেটা যে বললো যার শাস্তি ওই শাস্তি। এটা অনলাইনে ফোন করে। Just দেখি কি ম্যাটারটা। Yes, Mr. Banerjee, you were appearing in this matter.
I don't know, 58 has been called, no?
58, 59, yes.
Yes. 58. Yeah, I heard 53 with 59. So that's
So,
what
we are short of matters because we are unsure whether we have affirmative determination. Order for 20.
Yes,
Same
yes.
thing again, just a sentence time, the same thing happened. You are for the appellant.
Yes, my lord. Appellant, I'll tell you, Lordship, 58 if your Lordship takes it up.
তাহলে এটা বাবু একটু নিচে করে ওই আগেরটা এটা তাহলে এইটা গোটাটা হচ্ছে আগেরটা এটা সৌরভ সেনার
It is 58. Well, the suit was filed for recovery of possession of a portion in Nico House. The defendant was stated to be the licensee.
You are the defendant or the?
No, I am the, now that Nico House, that Nico Corporation has been sold part of it through CIRP process in NCLT. Through the process of auction, I have purchased it. So my application is to either be substituted in place and instead of the appellant plaintiff, or carry on in the name of the appellant or the plaintiff.
No, you have inherited the same company.
Same.
So
I have not inherited, my lord. I have purchased.
Rather, sorry, not inherited. I'm sorry.
I have purchased a portion of this property.
Portion.
Yes, I have purchased this property through a CIRP.
It's an eviction suit.
It's an eviction suit that was filed for.
So have you purchased that portion also?
That portion I have purchased.
So we'll let you continue in the name of the company.
Yes.
But you have an application. We'll decide that the other side is there. Who is appearing?
Other side is also not here.
No, but that application we can dispose of right now by saying by deciding it. I mean,
that I can just carry on in the
name of the company because
Yes.
the company is a juristic entity. It remains the same. The management has changed.
But Nico House goes, Nico Corporation goes into NCLT. So CIRP process.
Yes.
I'm really order 22 rule 10 scenario. I have purchased that property.
You are a company.
I am an individual lady. It doesn't matter. I'm an individual lady who has purchased this property through an auction process.
Yes.
Held by the NCLT. So really like order 20 rule 10, I have stepped into the shoes of. So because of that judgment, I can either come in, carry it on my name, or I can carry it on in the name of the plaintiff also.
Now, as per the CIRP, I mean, which was approved ultimately, what was it? The company, you have purchased a portion of the company.
I have purchased a portion of the property. Property, which is the subject matter of the suit.
Then we think you are right. 2210 scenario.
2210 scenario.
Because otherwise, company will be bifurcated.
This is not a case where management has changed the existence.
No,
that
you are
is-
separate individual.
This I have purchased through a process of auction, and I've come into the shoes.
What is the can of it?
Can is not to allow me to carry on in place and
Why
instead.
two appeals, Mr. Banerjee?
Lord, if your lordship looks at the can, I'm
So
sorry.
why two appeals?
There are two portions of the property. Two different portions.
But if there's only one can, you remain unrepresented in the other. And it names only can FA310. So 311 separate application. We are being technical, but I
Yes,
mean, it has to be. It's a separate appeal, separate thing altogether.
two separate appeals. One FA 31.
So an identical mirror image application you have to file in that also.
I think that is already there. My lord, there are two cans
Not
your lordship
appearing.
will find. There's a
No, দুটোতে can আছে. Oh yes, yes, yes. Sorry.
there are two cans.
Yes, yes, right.
1311 there is a can and
Then we'll allow.
310 also there is a can.
Mr. Mitra is leading you.
He's leading me.
How unfortunate. He should have appeared on the other side so that you could have. No, but
Yeah, it is not.
obviously,
for-
Order 22 Rule 10, Mr. Mitru, it's obviously, I mean,
Yeah, that has to be. Well,
but we have to hear formally the other side. I mean,
the matter I think was is to come tomorrow, Bodhi.
Right. Because
I
this
think
is
this matter and the next matter also I was called.
but to be taken up tomorrow.
I think tomorrow was the date because Mr. Radhika Singh came and he held a conference to remind me about tomorrow. Tomorrow.
which is why I said lady and I stopped short because
So she's a party here.
it's her suit. She has bought an
he has
auction
bought
sale in the
Pick
Nico's
up the matter.
this is specially assigned to your lordship.
Please.
So there also we know her too well. I mean, not in practice, but
Almost all matters get assigned to my lord. That's something.
because we do these things.
Yeah, but it's called.
But then you'd be no need not. Even if she's outside or inside, we know her. I mean,
No, that's
no, but Mr. Banerjee, that Mr. Mitra, the difficulty will be that you would be without courts. If everybody starts releasing, you'll be.
I'll be without.
So very well. Let us.
Not logic. Keep it tomorrow was the due date. I think that's what both sides.
That is one aspect of the matter. Who is appearing for the other side? We'll have to formally record a.
It's Ajay Mitra.
We'll have to formally record an order, Mr. Mitra, saying that we know the petitioner and that whether she agrees to it also. Us taking up.
He will object.
She may or may not agree. That's why, I mean, give a notice.
Lordship knows many people. Lordship. That's the whole difficulty. But just knowing, Lord, please do
I
not.
know many people who appear on the other side also. So we can understand, apprehend certain
Both sides,
objections being taken also.
Other side is also a lawyer. So that
Other
way
side is also a lawyer.
also a lawyer. So Taposh Datta.
Taposh Datta.
Taposh Datta. Lordship must have seen both. Lordship. So
Should release on that.
So it's balanced.
Is appearing,
So
then
it's balanced.
there'll invariably be a contempt in this. Mr. Datta is there in court? No.
No.
Give a notice. Somebody the advocate on record will give a notice to the other side. Was it fixed specifically
Yes,
tomorrow?
but was heard and Lordship fixed it.
Heard affidavit direction.
22nd July.
Was the date fixed that it will be taken up on this date? Let us see that.
Why tomorrow?
Assignment
Oh.
taken up on.
It was fixed on 22nd July. That's a Tuesday. Lordship takes up assigned matters, I'm told.
Or
on
is the
Tuesday.
date in which the previous bench took up assigned matters?
Yes, my lord's bench was taking up.
Yes.
22nd July. So the urgent date is so by default it becomes
Oh, acha, acha.
next. I mean tomorrow Tuesday.
Very well.
Because in his presence matter was.
And they took time.
We'll just say none appears for the respondent at the time of call. We'll request the learned advocate in record for you to give a notice. None appears for because we have removed that caption that these are taken up only on. Is that there still? We'll just check up. Assigned matters only on.
Everyone was under the impression that that caption is there. This is the
No. We have that caption. We have that. Today is a Monday, so yes. Sorry, our fault. Since so then we are not recording any, or both of you are here. The matter is called on for hearing.
Yes, presence doesn't matter.
Yeah.
All right. There no order need to be recorded. We'll take it up tomorrow. Assigned matter tomorrow. কালকে ডেট তো একটু খেয়াল করতে হতো টিউসডে অ্যাসাইনমেন্টের যে ডেট হ্যাঁ আমি একটু খেয়াল করবেন এগুলো কোন দিন কল করারই কথা না
50-59 এটা হয়ে gel.
Then same applies to the next few matters 57 about period.
Next matter also the
Next matter also 60, 61, 62 same.
That's not us.
We'll take it up tomorrow. No, not passing any orders.
60 also I'm his other side.
No,
So.
no, no. 60 we are not.
No, here we are together. So also don't say. Also don't.
Either you or him on the same side or on the other side. So you're all there. So we are wrongly taking up these matters. It's the court's fault. So you should have taken up on Tuesday. Thank you for pointing out.
Right side.
You are on the right side.
I will come back tomorrow. Assignment is tomorrow. So the other side maybe. Yes. 57 time Akirul ওটা কল করুন তারপর ডেথ রেফারেন্সে জাজমেন্ট দেব yes yes Mr. Chatterjee you start Mr. Shen what was your point just remind us sorry
Mr. G. Malad, appearing for the of the respondents, Malad, have cited Malad 2013 volume 7 SCC page 490. Malad, and thought to further point that
Mr. Banerjee was appearing for which party?
Respondent, my lord, I was appearing for respondent number 3. My lord, Mr. Banerjee was 1 and 2.
So all of you are objecting to or you are the proponent?
I am supporting the grant of probate. My lord, he is objecting the grant of probate.
And Mr. Banerjee?
Supporting the grant of probate.
But he was one of the citees there.
He was, my lord,
He was also cited.
he was the executor. My lord, I am the, my lord, one of the beneficiaries.
Right. So all of you are on the same boat, right? Very good.
2013 volume 7 SCC, Malad. He has cited Malad page 490, Malad, mainly Malad paragraph 20, Malad.
You are for Art 2, respondent 2? 3. So Art 2 means Mr.
Banerjee.
Yes. 2013 7 SCC 490 or AIR 2013 SC 2088.
2013 SCC, for SCC, Malad.
Which volume? 2013 7 SCC 490.
7 SCC page
Yes,
490.
we have that. Yes.
Malad,
Para 20 beside.
Malad, he placed Malad para 20, Malad. Para 20 in the present matter, there is no dispute the requirement of section 68 of the Evidence Act is satisfied since one of the attesting witness, that is PW2, was called for the purpose of proving the execution of the will and he has opposed to that issue. The question, however, arises as to whether the will itself could said to have been executed in the manner required by law, namely as per section 63C of the Succession Act. PW2 has stated that he has signed the will in the presence of Srimati Nagmani and she has also signed the will in his presence. It is, however, contended that his evidence is silent on the issue as to whether Srimati Nagmani executed the will in the presence of M. Malaraja and whether M. Malaraja also signed as attesting witness in the presence of Srimati Nagmani. Section 63C of the Succession Act very much lays down the requirement of a valid and enforceable will that it shall be attested by 2 or more attesting witnesses, each of whom has seen the testator sign or affix his will to the mark, and each of the witnesses has signed the will in the presence of the testator, as held by the bench such and such. Malad, thereafter the proposition of laid down by Venkatachala Iyengar. Thereafter, Malad, kindly come to Malad the para 22. Para 22, Malad, Janaki Narayan Vair has been quoted. Malad, that is 2003 volume 2 SCC page 91.
Mr. Shen, probably the paragraphs are tallying. We have been trying to follow you, but in vain.
Yes,
We have been following you, I mean, verbally, because this is a copy, this copy is given, I mean, we don't know from the website.
SCC online, Malad.
Not from SCC online. You have an SCC online copy. That's why the paragraphs are not tallying. There is a difficulty. He relied on para 1920 of this. So we don't know.
The paragraph starts with Janaki Narayan Vair.
That's para 19 here.
Fine.
The court has explained the interrelation. Yes.
Para 19, it starts in Janaki Narayan Vair.
But you started from the previous paragraph.
Starting from 19 onwards.
You started reading from where? What does that paragraph start with?
In the present case, just after 68 is quoted, 71 is quoted, Section 68 Evidence Act, 71 Evidence Act is quoted. Thereafter, my lord, para 20 starts in the present matter.
You have started from there.
My lord.
That's para 17 here. So yeah. Very good.
This Janki Narayan Bhairav, my lord.
Yes.
That is 2003. My lord,
Yes, yes.
my lord, I am supplying the copy, my lord. 2003, volume 9 SCC. Volume 2 SCC, page 91. My lord, if that, I am reading from para 2 of that judgment, my lord. Copy is based with the advocate on record. Contention asked by the learned counsel of the appellant that was not proved as required by law, having regard to section 60 of the Substitution Act. By whom was not as an of one of the Islamic attestation of by another attestation. Other attestation was not examined. But based on the proper application that allows for completion. On the other hand, the learning consequences are but decision at least by other that was one and one signatures. That is good.
2003 টা
But since it is referred in that judgment cited by Mr. Banerjee Malad, I am referring to that. Thereafter, Malad, I am placing.
If necessary, will give them scope to distinguish this if they want.
Right.
Only this.
This is it was cited in
Because,
the,
yes.
That's why Malad.
But you are referring. Very good.
Para 8 Malad, it says that the writ has been.
So you are referring to para 2(8).
Para 2(8). 9.
All right.
9 is very. Based on law. Thereafter, Malad, para 9. Thus, we have one requirement of the taxation policy of the which is mandated. Section 68 of the Agents Act as to how the document by law can according to the document by law the agency can all for the purpose of there can and the object process of the court by law the agency can one combined or made properly identified under by law of Section 60 of the Substitution Act. And sections that does not see that both or can see but
In this case, what happened to session? Both the attesting witnesses were called. Only one was called.
This case was relied upon in 2013. my lord.
Understood, yes.
Definitely, my lord, in this case, my
No,
lord,
no, in not this, in your case, the case which you are hearing, one attesting witness was called. And he had said that the other one was present or something.
that evidence is not there.
Somebody else said that.
No,
Testator said.
The
The executor said.
the propounder said, my executor
Propounder said that he was present. But that one attesting witness he was saying could not prove the rule. So section 71 scenario does not come in.
71 scenario does not help. 71 does not help, my lord. The 63C is mandatory. That is my point. That is my point. And
63C is not diluted by section 71.
that is what it has been held in this judgment. My lord, others, my lord, we have prepared, my lord, written notes of argument only that this factual submission. This is the only submission we wanted.
Yes, Mr. Chatterjee, you could deal with this.
Yes.
Only
My lord,
this.
very shortly, my lord, replying to this judgment.
Only this judgment, because it has been otherwise relied on.
Otherwise. Now, my lord, here, my lord, first of all, my lord, this judgment says, my lord, it can be proved by one attending witness. One attending witness came. My lord, one attesting witness said that the other attesting witness has signed. But what was not said so perfectly, my lord, was that the testator has seen the attested witness sign. So, my lord, that was taken care of by, my lord, one of the decision of which I have cited, my lord, 59, 54 2 Supreme Court cases, page 800. My lord, that takes care of, my lord, the issue. 54 2 SCC, page 800. My lord, I have relied judgment of Barker. হ্যাঁ 54 দেখিয়েছিলাম what has got 54
2 yes
আমার ওখানে পাতাটা বারবার নোট করা
para 13
para
13
yes
13 to be precise.
Yes, to be precise.
It cannot be laid down as a matter of law that because the witnesses did not state in examination that they signed the will in the presence of the testator, there was no duets.
So this was the question that was answered. Now, my lord, another thing, my lord, my argument was, my lord, in all way, my lord, they have stated that it was executed by the testator with an addendum that force was applied. He was taken by force. So, my lord, the force, my lord, issue of force, my lord, the sister's house, from where, my lord, the testator was taken out, that sister has never deposed before the court, and I have relied that it was a personal knowledge of that sister.
Yes.
So, my lord, the element of force which they alleged, my lord, nowhere, no, my lord, iota of evidence has come forward. Rather contrary, my lord, I have indicated, my lord, shortly, without taking my lord to the facts again, I have indicated the daughters themselves have said they have connection with the father all throughout. They visited the house. And, my lord, the father went to the registry office and everything, my lord, these were in depositions. Only that 63C, my lord's query was that non-stating of testator seeing the attesting witness sign.
Because that vitiates. You said only that by itself does not.
It does not. And, my lord, if the execution is proved, my lord, 2006, then, my lord, my burden is discharged. It's now, my lord, the other side's caveator's burden to prove the allegation of fraud, coercion, force, and everything. So, my lord, execution on my part have proved. My lord, this is in short, without elaborating much more on facts.
Yes, so your written notes you are
Yes,
filing.
I've
Mr. Banerjee's written notes.
My lord, Mr. Banerjee has stuck in other court, I am told.
No, his junior must
Here
be
is here.
No, do you have your file? Do you have the written notes ready? The closing arguments on this. Should have just asked him whether the written notes are ready or not. You have to file written notes only. Ask him, will grant you leave to file by tomorrow. If you are ready, we can file today itself. You are for respondent number 2.
No, 3.
You are 3, right? Why don't you indicate why we are
very well? No, if my lord permits by pen, I indicate.
No, I'll respondent number 3.
On the written notes, it has been mentioned.
Oh, my lord, this is the index page in the written notes, my lord, that has been mentioned.
At page 3.
No, at the top, because
Yes,
when you take
Oh,
up the
sorry,
matters,
sorry, that should have been in the first page.
Yeah, 3 is there inside. Very
But, as a double caution, we have annexed those judgments in the written notes also.
Yes, yes, we have seen that. Thank you. And your judgment, Mr. Shane, one judgment you have handed over right now. The others you had already handed up on the last occasion, all the judgments. This judgment you have handed up today, no difficulty.
This was cited, madam.
Anything which was cited but not handed over, just hand over today. Which you have already handed over, one or two you have handed over previously also probably. I don't. Rani Purnima Devi you had handed over, Bhagwan Kaur, Niranjan, Leela Rajagopal.
My lord has been hearing well this matters.
Meena Pradhan, no, we have to advert to the judgments, that's why. Kavita Kanwar was not cited all that time.
এটা কোনটা ছিল কবিতা কান্না আমার নাম মনে থাকে না ইয়ারটা বলো 21/11
And my lord, one more issue was that order 41 rule 27 they have filed. I have shown it doesn't fall under the sufficient cause. My lord, I have relied upon a decision of.
They wanted to do what? By
Well, there was another will executed on the same.
Oh, that
day
was not
of the-
proved.
Yes, yes, yes.
That was not marked as an exhibit.
That was not marked as an exhibit, but the record.
You want to do that.
Original
But the court adverts to that.
court took cognizance of
yes.
that, my lord, and passed on. But it did not refer to the consider that it was done in a different registry office. Court thought that on the same day he has executed 2 wills on this
Different properties.
Barashat and relating to different properties.
Yes.
But the fact that it was done in Salt Lake, that was not considered.
But that you have put in your written notes of
My
arguments.
lord, everything has been put in.
You argued at the time of
Yes,
argument,
my
you
lord,
mentioned that we remember.
My lord.
Yes.
That we
My
remember.
lord, kindly consider holistic.
Very good. Heard learned counsel for the parties, full stop. Arguments are concluded, full stop. The learned senior advocate appearing for the appellant and learned counsel appearing for the respondent number 3 files the respective written notes of arguments, full stop. The leave is granted to the respondent number 2 to file respondent numbers 1 and 2 to file their written notes of arguments by tomorrow. If you have that ready, just file it during the course of the day to our officer. We have given you till tomorrow. If you have it, file it today after asking Mr. Banerjee. Thank you. Judgment is reserved in the matter. এটা পাঠিয়ে দেবেন ওই
Regarding the FMAT, this order 41, my lord, if matter is ready for order 41, there is no section 5 or nothing like that, my lord can take up.
One difficulty, Mr. Shane, that if total exclusively FMAT is given to someone else, FMAT without any qualification, first miscellaneous appeals, applications in connection therewith. Now, and order 41 is a stage of hearing. Stage of hearing. But if the subject matter jurisdiction is given exclusively to someone else, that is the doubt. Whether we have, even for order 41, that bench has to hear this FMAT.
No, sir, since order 41, my lord, after order 41, that bench will hear, my lord.
That is the notion, but the list does not say so. It should have said that order 41 FMAT matters which are ready for hearing or applications in connected there, the other bench.
The other benches say FMAT connected with applications connected there.
Therefore, FMAT determination exclusively with that bench, including order 41 admission stage. And FMAT, most of them are decided at the admission stage, which was
But,
the friction point when Justice Tandon's bench was taking up, if you remember.
My lord.
Order 41 and we had, and you also moved and we also asked the Chief Justice Office, the same thing has been repeated.
The moment it is admitted, application is there, my lord, that will go.
Yes, that will go, but unnecessarily, because 90% of the cases, if it's injunction appeal and if it's remand appeal, it should go before a single judge. Most of these are either receiver or injunction, these FMATs. So we decide generally, in most of the cases, we decide then and there by hearing both of you, unless somebody has to be served and all these things. But that thing will go away then. And also, order 41 is a stage of hearing. If somebody has exclusive determination of FMAT, we don't know whether we have determination of order 41. That may be the intention, but that's not there in the this.
Only thing is the order 41 files have not gone. Those are remaining with.
No, we are not doing that right. Order 41 we have.
No, but that's why, my lord.
Even FMAT order 41, we are not sending the files. We are just adjourning the matters for a week. If we relegate it to the other bench says, I don't have determination.
No, I'm saying the converse. The other bench is of the view that only hearing matters will come before this
Of
lordship.
the view, but the list does not say so. We have checked up the list twice, thrice.
Yeah, when we joined the bar, Malad, it was a practice, Malad, first appeal, order 41 in one bench.
In
Malad.
one bench.
Now, Malad, it has been
Why,
bifurcated.
when you joined the bar, even when some of your learned juniors joined the bar, till recently,
Till recently, Malad, this bifurcation, Malad,
same
creates problem.
determination, civil matters, same determination.
Same.
So that the lock, stock, barrel, it can be decided.
But now there are various number of acts, Malad, where they should be treated as first appeal, order for whether they will be taken as order 41. That difference is always there.
That is also there, but yes, those matters we can relegate to the regular bench having determination.
But if,
But if
there
that clarification is also given,
for 1 week, Malad, order 41 are not taken up, Malad.
FM it is 1 week, 2 weeks already has gone by. So no difficulty in one other week. Better than passing an order after and then.
My lord, in the meantime, my lord, Justice Orjit Banerjee's bench, having my lord's determination, admitted order 41 in MFM. Did that.
We would love to admit and decide.
We love to, my lord, appear before me, lord.
Not that.
But at least, Malad, here's Malad order 41 stage and Malad application.
Mr. Sen, you don't understand. The wait is for a week only, but the difference is that a matter being admitted and relegated to another bench, an injunction matter being relegated to another bench for hearing. That is the difference. And between the order 41 being admitted and decided at one go. That is the difference this 1 week will make. Either Justice Sen does that or we that bench does it or we do it. Whichever bench. But it has to be at one go, most of the injunction matter. So that difference, the wait of 1 week will be fruitful because ultimately the result will be that one bench will hear it and dispose it of most of the injunction appeals. Unless there is a service direction required. Very well. কালকে উপরে